Please rise. Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division, draw near to the attendance, and you shall be heard.
Good afternoon. Welcome to the Appellate Division First Department. We have about 6 hours of argument time that has been requested, so please bear that in mind as I call the calendar. Remember that we have your briefs, we have your record, we're fully familiar with the facts of the case. Okay, first case is People versus Deshaun McIntyre. Submitted. 5th and 55th versus Vistana Signature.
6 and 3 for rebuttal, please.
6, 3, and 6. Yamani D. is submitted. Trump versus Trump.
James Howley for the respondent, Donald Trump. And Sean
The appellant first, please. And how much time, please? And? No, that's not unhappiness. It was just a, let me see what the other side asked for, is what it was.
James Howley, 10.
Okay. 8, 2, 8, and 5. Manfredonia versus 750 Astor.
Appellate 750 Astor, 3 and 2, please, Your Honor.
Appellant Jewish Board, 3 and 2, Your Honor. Respondent 6.
3 and 2, 3 and 2, 6. Houseman versus Bauman.
Good afternoon, Your Honors. Albert Chang on behalf of the appellants. 10 and 3, please.
Keep your voices up, please.
Joel Kurtzberg on behalf of the Credit Suisse defendants. The 3 will be combined. Bank of America and Credit Suisse.
10 and 3, 8 and 3. Thank you. People versus Sherman Arthur is submitted. Trevino versus Prey, 2 appeals, 5404 and 5323. Okay, I'll give you 4 minutes. 4 and 2. And you, counsel? 3 minutes. Thank you. People versus Melinda Ratliff. 8, 2, and 6. I'm sorry, 6, 2, and 6. Najira Ordonez versus 260 Partners.
Appellant's request 7 and 2. Respondent 4.
7, 2, and 4. Gillespie versus Kling. I don't see a respondent. Do you wish to submit? I mean, unless, is there anybody here? This is, okay, a submission, thank you. People versus Joel Levine.
Glenn Garber for Joel Levine.
Levine, sorry.
6 and 3.
6, 3, and 6, Yusuf versus Horace Plaza. I don't see a respondent. Do you wish to submit? 2 minutes and a submission. First case for argument is 5th and 55th versus Vistana Signature.
Good afternoon, James Batson on behalf of Appellant. I would like to introduce Christopher Langone, admitted pro hoc vice, and request permission that he be permitted to conduct today's argument.
It's granted.
Thank you.
Thank you. May it please the court. My name is Chris Langone. I represent the 5th and 55th Residents Association, which is a common interest association concerning fractional interests at the St. Regis Hotel. And the fractional interests were developed by an entity called the sponsor, St. Regis Residence Club of New York, Inc., and a manager, the St. Regis New York Management Company, Inc., manages the club. The claims are for breach of fiduciary duty, unjust enrichment, and tortious interference with contract.
Counsel, the causes of action here seek purely monetary relief, not elements of fraud. So why should we find with the 6-year statute of limitations versus the 3? Since this appears to be monetary, it would be the 3, wouldn't it?
Well, there are elements of fraud in terms of fraudulent concealment, but more fundamentally, disgorgement is an equitable form of relief that results in the application of the 6-year statute of limitations. We're not calling this disgorgement in merely the sense of like a refund of management fees, but one of the core allegations is that the sponsor and the manager profited from the sale of the hotel as a result of inflating the occupancy rates by using the rental program's rooms as overflow rooms. So for instance, when you're seeking disgorgement, that money is not necessarily paid by the plaintiff, but a third party. So the sponsor, the hotel, and the manager profited from the sale of the hotel to Marriott, and those profits were derived as a result of their manipulation of the rental pool. So we do believe that, and the cases we cite in the briefs that talk about disgorgement as an equitable remedy would allow for the 6-year statute of limitations. Although we do believe that there were also elements of fraudulent.
So then, counsel, how do you distinguish our decision in Access Point Medical in which we said straight up that a claim for disgorgement is a money damages claim?
Even though it's money damages, it's still equitable in nature.
It's not equitable in nature if it's money damages, correct?
Well, it's.
I mean, how you get to the number is not whether or not it's money. You're not seeking a declaration. You're not seeking a preliminary injunction or a permanent injunction. You're not seeking an accounting. You're seeking money. Money, and the way that you calculate the money is through disgorgement of whatever you think should be disgorged, correct?
True, although
So
it's.
then again, I'm going to ask you, how do you distinguish Access Point Medical?
I'm not familiar with that particular facts of that case to distinguish it, although I would note that just because it's money, it's still equitable because it's not money based on compensatory damages or damages as a result of what the plaintiff suffered.
But so, for example, lost profits is a money damages claim, correct?
Yes.
So isn't this similar to a lost damages? You're saying disgorgement somehow makes it equitable. That's what I'm trying to figure out.
That's the case, and I'll look at and maybe deal with it in reply, look at the particular case. I would also note not all the claims are subject to, would be barred by a 6-year statute of limitations. The statute of limitations is an affirmative defense. It's not being shown by documentary evidence as required by the rules, and certain
But the
claims.
motion, Counsel, the motion clearly talks about a statute of limitations, correct?
Yes, but it's still.
And even though they don't directly relate to 3211.5, it's clear from the totality of the motion papers that you can reasonably infer a major argument on the statute of limitations, correct?
As to some of the claims, for instance, going all the way back maybe to the, conversion of the key count. But for instance, as to the manipulation of the rental pool, those would be even within the 3-year statute of limitations because the claim was filed in 2017, so a 3-year look-back period goes to 2014, and the manipulation of the rental program occurred after that. We also allege that there's equitable tolling as a result of the sponsor exclusivity period and fraudulent concealment. And I see
Thank
that
you.
my time is up for the balance for rebuttal.
Good afternoon. Chris LaRocco of Bryan Cave, Leighton Paisner here for the respondents, defendants in this action. Just to pick up where my colleague left off, I'll say that I believe Your Honors have identified the statute of limitations issue correctly, and that the plaintiff really has done nothing to distinguish this from Access Point or the subsequent precedent. I mean, again, that's not the only case, that's just the wellspring from which this case law comes, in the sense that they have alleged, if you read the first amended complaint, there are numerous allegations specifically alleging monetary harm to the members of this organization and the organization itself. There is no distinguishing the facts of this case from those cases where a plaintiff will add a claim for disgorgement or some other equitable relief that is incidental to the actual relief they're seeking. And I believe that's the case here, which puts us in the 3-year statute of limitations. And just to address something that counsel said, it is not the case that there are some that would still be outside of the statute of limitations bar. All of the discrete actions that are actually alleged in this complaint all took place well prior, frankly, some of them prior to the 6-year statute of limitations, but certainly prior to the 3-year statute of limitations, that period of which starts to toll, or I'm sorry, not toll, but run in May of 2013. And so we have allegations of the addition of certain units to this club in 2007 and 2008, the changes in the condominium fees, which counsel referenced, that happened in 2008, the cessation of marketing efforts happened in 2009, and then club renovations, which take place in 2012. These are all discrete actions that clearly took place prior to the statute of limitations. And I think, if you read the decision of the motion court, he was clearly focused on that and ruled in many respects with respect to each of these claims on that basis. And just to continue this point, while they have sort of asserted this idea of fraud or concealment, the complaint contains no such allegations.
So then, counsel, let me ask you, how do you respond to their argument that this is a continuing wrong and therefore we should stretch the statute of limitations beyond the 3-year look back, or more than the 3-year look back?
I don't think any of the alleged wrongdoing here can be characterized as continuing wrong. Again, I just went through this list, and I'll say that, again, the club added units in 2007 and 2008. It did not continue to do that, or at least that's not alleged, and in fact, it did not. There were changes made to the allocation of condominium fees. That took place on a date certain. They didn't keep changing the allocation of those fees. They stopped marketing efforts. That happened at a particular date and time. The renovations were approved by the club board on a certain day in 2012. So these are not the kind of wrongs where, and again, with respect to the rental pool, I would say that, again, we're relying on that as sort of this marker of potential equitable relief. But frankly, that's the only claim here where that's a potential argument in terms of continuing violations, because there may be rentals that would continue to happen after this date in 2013. And to the extent that they had pled specific rentals causing them a specific harm on those dates, then maybe they would have an argument, but there are no such allegations in their pleading.
Just going to go back to the fraud issue.
Yes.
Because when I looked at the complaint, I really see allegations dealing with conflicts of interest, self-dealing. I didn't see anything about the elements per se of fraud.
Oh, I agree with that analysis, Your Honor. I think that, putting aside the allegations of self-dealing, which we don't agree with, obviously, but to the extent that there are these allegations of fraudulent concealment, which I think is specifically alleged as our client, the defendants refused to provide certain information that they were seeking, first of all, I don't think that claim is well pled. It's not particularized in terms of who those requests were made to, what happened, what they had done to try to resolve those issues, when those requests were made. But nonetheless, requesting information, even if I'm obliged to provide that information and I refuse, that is not fraud, right? That's a breach of contract to the extent I was obliged to provide that information. But there's no misrepresentation alleged, and certainly not with the particularity required under the CPLR for a claim of fraud, which is essentially what would be required to stop or to toll the statute of limitations here.
Didn't the original agreement allow the sponsor and the manager to prioritize the hotel units and treat the club units, for want of a better term, secondary citizens in this process?
Right. So with respect to the hotel, it's not specifically stated in the offering documents that, the hotel will rent these interests above yours. It is, however, stated directly in the separate agreements that everybody signs when they, enter into this program, which is completely voluntary. Now, it does say, however, that a member, somebody purchasing this, should have no expectation of rentals, that you're going to compete at a substantial disadvantage with at least the sponsor. And the Southern District of New York read those same documents and determined, there's nothing on here in which the plaintiff to base this idea that there's a right to rental parity that has been, that has been countermanded. I mean, there's no basis for them to have an expectation that they're going to have to be able to rent hotel rooms in parity with the hotel. This is not buying a hotel room. It's a deeded interest in a fractional offering. So it's a different thing. It's not specifically mentioned, but I do think that reading those agreements in a totality, as the Southern District of New York did, it's impossible to conclude that somehow a member purchasing an interest would have an expectation that they would have rental parity with the hotel.
Thank you.
Thank you.
So as to the statute of limitations issue, first, as to the rental pool, the complaint alleges, record page 51, starting at First Amendment complaint, paragraph 11, that beginning in 2012 and continuing through 2015, that's when the $2.7 billion kickbacks occurred. So that period, 2012 to 2015, is clearly a continuing violation, 2015 being within even the 3-year statute of limitations. Those kickbacks, by the way, were not even discovered until a document that was produced in the federal Gillespie case was obtained and then made public through the Gillespie case. So the discovery rule would be another reason why the statute of limitations wouldn't apply. As to the fraudulent nature or fraudulent concealment, counsel indicates that we didn't plead that, but it wouldn't be our obligation to plead around a statute of limitations affirmative defense. I think this, again, is an issue where why it's an affirmative defense is so important, because they would need to allege the affirmative defense, and then we would be able to show through discovery, and it becomes a summary judgment issue as to whether there's continuing violations, whether there's equitable tolling, whether there's fraudulent concealment.
So in response to their motion to dismiss on the basis of the statute of limitations, what did you put up with
Fraudulent concealment,
Yeah,
continuing.
what did you put up to show fraudulent concealment? You said, other than saying the words, how did you raise an issue of fact with respect to that?
So, for instance, the sponsor controlled we allege didn't share various books and records and financials that would have shown information that the independent board would have been able to discover. Because remember, the sponsor.
And you're saying, said you relied on the failure, because obviously you have to raise issues with respect to all of it. You're saying you relied on the fact that the board didn't provide you information?
Well, a material omission, you wouldn't have to rely on an omission, but because they didn't provide the information, the fraud couldn't be timely discovered. And again, this is why a factual record needs to be developed.
Well, but I mean, at least you have to have somebody say that that's true. You can't, it's a motion to dismiss. They put in papers on the statute of limitations. So if it's now the burden shifts to you, because obviously most of what happened here happened between 2008 and 2012, more than 10 years ago. So I'd be surprised if you didn't think that statute of limitations was coming up. And in fact, it was raised in all the other lawsuits you brought. So when it came up, what did you put in opposition?
Well, first again, we cited,
You just said they didn't give us some documents.
that's part of it. Again, for under CPLR 3211A, for them to win on statute of limitations on a pleading motion, they have to submit unambiguous, authentic, and undeniable evidence, which they didn't do. This isn't like they submitted a document that shows on its face. There are numerous fact questions.
No,
about
they
the statute.
submitted your complaint in which you alleged everything from 2008 to 2012.
But we
Right?
also
That's
alleged,
your document, right?
and there are still millions of dollars at stake as a result of the rental pool manipulation and the RevPAR. If that's the only part of the case that goes back, it's still a multi-million-dollar case.
Thank you. Thank you all. Trump versus Trump.
Good afternoon, Your Honors. May it please the Court. Under New York law, there is a special rule that applies when a general release is being applied to claims that were unknown at the time of the agreement. Such a release of unknown claims must be, quote, clear and ambiguous, such that it was clearly intended to reach the unknown claims. In addition, and this is of key importance here, such a release must also be, quote, fairly and knowingly made. That comes from the central case, Judge Saperik's opinion, 2011.
So, counsel, if first you'll just bring the mic down a little bit.
Oh, I'm sorry, Your Honor.
Yeah, perfect.
I like to think of myself as taller.
Yes, and you are a tall presence.
It is important for me to point out. at the
May I just
outset-
ask, that wasn't the only thing. I'm just saying, you're talking about the release here, the general release, as well as the settlement agreement seem to have really broad language talking about forever and anything that's ever come, and hasn't even been thought of yet. So, given that scope.
So to release these unknown claims, Your Honor, which were unknown and have nothing to do with what was settled at the time of the grandfather's probate proceeding, it has to be fairly and knowingly made. What's not fair and not knowing? Well, two really important things. First of all, the Trump siblings threatened my client, Mary Trump, with bankruptcy, essentially, having to pay taxes for years and years on assets she didn't own. But we can even put that aside. Let's take the most dramatic and most shocking fact that we allege in the complaint, and that is that the Trumps cut off health insurance to Mary Trump's infant niece, who was critically ill in the hospital. In fact, they admitted it to a newspaper. We cite that in the record, that that's what they did, in order to force her to sign this release. If that's not unfair, Your Honor, it's hard for me to imagine what would be. And if that's not unfair, it's hard to imagine that the rule set forth in the central case is still the rule in New York. These are extreme, dramatic circumstances that at this point in the proceedings you have to accept as true on a motion to dismiss. And telling an aunt of a sick infant child that he's going to not have health insurance to pay for his extremely expensive medical costs if she doesn't sign this release, it's hard to imagine anything that's more unfair. I wanted to be clear. Mary Trump here is not trying to undo the probate proceeding. She's not trying to undo the releases Justice Renwick that you just referred to. She accepts that those are valid releases. But the standard which Justice Reed focused on the trial court was the fraud standard. That's the standard, or duress standard. That's the standard that's required to undo the probate proceeding altogether. We're not trying to do that. We accept that release. We're trying to bring a case for a fraud that was completely unknown, that it took the New York Times, 3 reporters, 3 years to uncover, that they won a Pulitzer Prize for. And
What do we do about the fact that she had the very documents, excuse me, that she provided to the New York Times? One would say, why couldn't she have discovered it?
So all the documents that she had, Your Honors, were documents concealing the fraud. They were all the fake books and records of the entities that she had inherited from her father back when he died years and years before. And what the New York Times did is they took those false financial records, they then compared them to the tax returns, and based on that, they uncovered the fraud. That's not what Mary Trump had. She only had the concealing of the fraud, not the uncovering of the fraud. And under this court's clear precedents, including, let me give you the best case, Your Honors, including excuse me, this court's decision in Norderneutsche Landesbank, I can't pronounce German, 149 AD 3rd 152. Judge Scarpula in a case, this is the case about the Trump Foundation, pointed out that you can't decide these kind of facts on a motion to dismiss. And it shouldn't be decided on a motion to dismiss here. And here again, she only had facts, she only had documents concealing the fraud. Yes, Justice Scarpula.
But I mean, like, this release is a standard release that we have held up a million times. And your client has said in this release that all causes of action which the plaintiff ever had, and not only that, but you did include a carve-out. So it's not like you didn't know what you were releasing. There was a carve-out in this release, right?
Yes, but
So this release didn't carve out, it carved out certain things, but everything else, it's a standard Blumberg release that we have upheld many times.
Actually, and you're right, Your Honor, if she was trying to undo this settlement, then you would be 100% correct and you would have to uphold the release. So two things. One, she's not trying to get out of this settlement. She's trying to get out of a fraud that she didn't know about. And under the standards set forth in Mangini, a Judge Breitel decision, and Centro, if it wasn't fairly and knowingly made, which Justice Breitel said is a far lesser standard than fraud and duress applied by the trial court below, then she can bring those claims, number one.
20 years later, you can go back 20 years.
Well, she only found out about it. That's what happened. They did a very good job of hiding the fraud from her. And she was a young kid when this started.
I want to go back to that. So young kid, I thought she was like in the 30s when this happened.
When this happened, but when she inherited the assets from her father, and when they were doing this fraud of siphoning out assets, siphoning out value from the assets she inherited to themselves, that started when she was a young girl.
So how do we deal with the fact?
And they were her fiduciaries on top of that.
How do we deal with the fact that, the alleged threats, the alleged, withdrawal of the health insurance? I mean, that happened, before she indicated that she voluntarily entered into the agreement under no compulsion to do so. So how do we deal with that?
So that's exactly the point, Your Honor. The fact that she entered into this agreement as she did, because she was told that if she didn't, they would not continue to pay for the health insurance of her gravely sick nephew, is exactly the kind of unfair, not knowing circumstances that doesn't bar claims that are settled at the time, but that does bar claims that were unknown, that doesn't bar claims that were unknown at the time. And again, if there's any life left, which I think there is, Your Honors, because you have cited it, both of you have cited, Justice Renwick and Scarpula have cited it recently, if there's any life left to Centro, then it has to mean that threatening to take away life-needed or medically needed care for a critically sick child is exactly the kind of circumstance that would not allow a release to bar unknown claims.
Does it undermine your position at all that health insurance was not incorporated into the settlement agreement, if it was such an important and material concern, that the claims regarding, the Nassau County claims regarding the health insurance were discontinued?
Yeah, but that was part of the overall settlement. They did continue the health insurance as a result of her signing all these agreements, and the child was cared for in the future as a result.
As with the proceeds of the settlement?
That was my understanding, that she had money that was allowed her to pay for it, correct?
Was she represented by counsel?
She was, but as we
The entire time?
But as we, no, I'd have a hard time if she was trying to get out of the probate proceeding. But for an unknown claim where they put a gun to your head and say, you signed this agreement or you're taking your nephew out of critical care, that's exactly what Centro and Mangini say. And Justice Breitel in Mangini says it's a far lesser standard. And in fact, one more thing before I sit down, Breitel also says that you don't focus on whether she's just represented by an attorney. You don't focus just on the Bloomberg language in the release. You look at all the circumstances and whether it was fair or knowing. And I respectfully submit it's hard to imagine a more unfair circumstance.
And just with respect to that, as one of the factors you look into, we talked about age, and you say she's young. How old are we talking about, and when are we talking about with regard to the age when this happened? When
at the time this agreement was settled, this agreement was done, she was in her 30s. When
That
the
I know.
fraud started,
That's what I'm
she was a
talking
young
about.
child. She inherited money from her father.
Are we talking under 18? What are we saying when we're talking about young child?
Oh, I think she was in her 16 when her father died. No, no. And her aunts and uncles were her fiduciaries who were supposed to be looking over these assets for her benefit after she inherited them from her father. I see my light is red, so unless there's another question, I'll save my 2 minutes.
Thank you.
Thank you, Your Honor. Your Honors, good afternoon. James Kiley for the respondent, Donald Trump, and Sean Hughes as the executor, Robert Trump. I would like to address this notion that the health insurance was being withheld. First of all, it was gratuitous. She brought an action. She settled it without consideration. It was gratuitous. They didn't work for the company. And the decision to settle was made after there was a stay in the Nassau Supreme Court. So this was not looming over her head. She had 18 months, a year to contemplate this. This wasn't a last-minute thing. And I think it's important to note that the allegations in the complaint are conclusory. She's saying that they threatened to not pay the health insurance. All that means is they were threatening to transfer the financial responsibility to pay health insurance to her brother, okay? They don't plead that, well, listen, because of that, we couldn't get insurance, there was an exception to pre-existing conditions, we couldn't get Medicaid, none of that is pled, okay? None of that is pled. So it's conclusory, and the court should not consider conclusory statements. And as Your Honor mentioned, if this was such a cudgel over her head, why didn't she carve that? Why didn't she expressly provide consideration for that in the settlement agreement? She chose to take $1 million for herself from her grandfather's estate rather than allocate money, to be paid for insurance going forward. This notion that Robert Trump threatened her, a year before in a restaurant, I mean, geez, if that's all you had to do to vitiate a release, is say, hey, move to say that a year before he threatened me, you'd never be able to successfully move to dismiss a case based on a release. All they'd have to say is, well, a year before he threatened me in a bar, in a restaurant. With regard to the lower court's decision, the lower court found, as a matter of law, there were no unfair circumstances. The lower court found that the release was fairly and knowingly made.
What about counsel's? Okay. You can go. Just what about counsel's reference to Centro and the fact that it has to be fairly and knowingly made, and that at the time there were just unknown causes of action?
No, it was fairly. What was fairly and knowingly made were the circumstances. There were no circumstances, as she suggests. As a matter of law, they were not unfair circumstances to threaten to cut off health insurance or to threaten to bankrupt.
The causes that were unknown, that she couldn't have known because she was a child at the time these things were, she wasn't able to uncover them.
Well, first of all,
she was relying on fiduciaries, and so that this was not discovered.
The gravamen of their claim is that All County and Apartment Management Associates were not legitimate. Those companies were formed in the 90s when I believe she was 30, right? She's 36 when she settled these cases. So she knew about All County. She knew about Apartment Management Associates through Robert's deposition, through John Walter's deposition. So she was aware of the knowledge of the facts.
You mean as part of the probate proceeding?
I'm sorry, Your Honor?
As a part of the probate proceeding, she had information about the assets?
In the 1404 hearing of Robert Trump, he was questioned with regard to All County Building Supply, which is her main allegation of fraud, which we deny, obviously. He testified at length that it was a middleman, that it marked up goods. We formed it to mark it up. It was a centralized purchase agent.
I guess what I'm trying to figure out is, was there an opportunity to do discovery to find this out at the time the proceedings were pending?
Yes. Well, first of all,
there's the healthcare proceeding, the probate proceeding, correct?
There was enough information adduced in the 1404 and the probate proceedings for her to find out what All County was, what its business purpose was, that Apartment Management Associated had replaced Trump Management, that the children had formed their own management company. She knew all this. her attorney inquired. He even had the same records the New York Times referenced.
Well, that's the key, right? Because part of their claim, as I understand it, or their allegations were that they were working with or inspecting cooked books, so to speak.
There were no cookbooks. There were no cookbooks. They didn't hide All County. There's no allegation in the complaint that they took All County and made it something else. It was all there. All County was all there. The numbers were there. Apartment Management Associates, they testified openly to it. Because they believed they were being compliant with the law. The issue about notes that had unfair terms, unlike the Epiphany case, that's a glaring example where that defendant, he first wrote it as a loan, then he changed it to receivables, then he crossed it out and changed it to something else. None of that happened. This was all on the books. It was All County Apartment Management. There were no cookbooks. That's an inference that's based on nothing. Moving along with regard to the, aside from the release, the statute of limitations argument, again, she's on notice of this stuff. She's got boxes for 18 years. She keeps talking about the New York Times Pulitzer-winning story, but the only part of the story that addressed Mary's issues were based on the facts that she had, were based on the deposition transcript of Robert, was based on the grats that she'd been given. You know, she says, I didn't know. All she had to do was do her own appraisals. Now she's saying, well, listen, the income was different because of All County, but they could have looked at that and saw what All County costs and what the expenses were.
They're saying whatever was in the box said what it said, but that's not, they had to do extrapolation to sort of figure out what it meant or what it didn't say.
No extrapolations. All you had to do, if you look at the New York Times article, they looked at the valuation. She's claiming we got these phony appraisals. All they did was look at publicly available records and see the comps for similar buildings in the similar neighborhood and say, wow, these buildings are worth 2 and 4 times more than what they claim they're worth in these GRAT valuations. There was nothing, if you read the New York Times article, the only issue, you know, the New York Times article went into, you know, much more detail about Fred Trump's wealth and through the years, but that which only relates to Mary Trump's claims all came from her file. The deposition transcript of Robert Trump, the deposition transcript of John Walter, the GRAT valuations, the appraisals.
What is the materiality, if any, of her litigation counsel was recommended by Mr. Durbin, who had been a close confidant of Fred Sr., and that he was allegedly a co-conspirator in this?
Those are conclusory claims, but we'll put those aside. But certainly the fact that because he referred John Barnofsky, that based on that alone, her attorney was conflicted without an allegation that, oh, they had, there's no allegation. Did they have a common business practice enterprise? Did they share an office? Did he give them money? None of that is alleged. It's completely conclusory.
Did Mary Trump ever sue her lawyer?
She never did.
Did she ever sue the trustee?
That
referred her, Mr. Barnofsky?
She never sued her lawyer for malpractice. She never sued the trustee, no. Yeah.
Thank you.
Okay, thank you, Your Honors.
Good afternoon, Your Honors. My name is Gary Friedman from Greenfield Stein and Senior, and I represent Respondent Marianne Trump Barry. Turning to Mr. Barnofsky. Mr. Barnofsky at the time, in around 2000, was one of the leading probate litigators in the state of New York. The fact that he was referred by Mr. Durbin is, with all due respect, of no moment. Mary Trump was not, they didn't say you must hire Jack Barnofsky. I'm sure she interviewed him. She may have interviewed others, who knows? But if she did any due diligence, she would have seen that he is an experienced probate litigator. The only allegations in the complaint is that he's compromised. That's a conclusory statement. That's not a factual allegation indicating that Mr. Barnofsky had loyalties to anyone other than to his client. In the settlement agreement, the plaintiff expressly disclaimed any overreaching or unfairness. in return for the several $million that she received. Let's remember, she didn't receive $10 as plaintiff now argues. She received $962,000 to settle the probate contest. She received $1.8 million to sell her interests in Midland and in the other land entity. And in the settlement agreement, in consideration of the funds received, she said that the execution of this agreement is being completed on a voluntary basis and that she represents that she was under no compulsion to execute this agreement and that she had sufficient opportunity to review it with her attorney and has executed the document after due consideration and of her own volition. And as my colleague here pointed out, it's not like they stopped paying the medical insurance 2 days before the settlement agreement was about to be signed. This had all been going on for a year and a half. There was a lot of litigation in the surrogates court. Lots and lots of documents were produced, 18 cartons of documents. And in those are the documents that were turned over to the New York Times and from which the New York Times wrote the article and mentioned All County.
But does the procedural posture of this case make a difference in that it's a 3211, and on a 3211, we must accept the allegations as true and accord the plaintiff the benefit of every reasonable inference to be drawn therefrom? We have to look at all of the allegations, not each allegation in isolation. So we have the quote-unquote threat, in deference to you, I'll use quotation marks, the threat to take away the nephew's health insurance. We have her relative youth compared to her aunts and uncles and their positions of power and strength, that familial relationship, that quasi, or at least in their eyes, a real fiduciary relationship. Viewed through that 3211 lens, why isn't that enough to go to discovery and then produce a full factual record for summary judgment?
Number one, she was not a child of tender years when she executed the settlement agreement. She was 36 years old. The case law is crystal clear that even when there was a fiduciary relationship, once it turns adversarial, there no longer is that duty owed. And here, the allegations of the complaint are wholly insufficient, especially in light of documentary evidence. They had, in those 18 boxes was Robert Trump's deposition testimony. He testified to everything that was in the New York Times article. They quote extensively from his deposition in the Times article. So she had this information. These weren't unknown claims. So putting aside the language of the release, the claim is time barred because she had knowledge, she had the operative facts in her possession and in her attorney's possession for 20 years before she brought this action. I mean, Robert Trump testified that All County was owned by him and his siblings and his cousin, John Walter, that the very purpose of All County was to mark up and to generate a profit on its own. What does that mean? It was clearly a middleman. There was the facts, so there was an alternate basis. Even if the court didn't dismiss on the basis of release, it should have or could have dismissed on the basis of statute of limitations. Because when you rely on the 2-year discovery rule, she has to prove, the plaintiff is required to prove that even if she had exercised reasonable diligence, it could not have been discovered. It clearly could have been discovered. The Times discovered it from the 18 boxes that she had, the tax returns, the financial statements. I see my light is up, Your Honors.
Thank you.
Your Honors, most of what I heard my friends on the other side say, and I'm just going to repeat it so Your Honors are clear, that there was no fraud from the Trumps. There were no cookbooks by the Trumps. That Barnowski has the greatest reputation in the world and he never could have done anything wrong. Not one word of that is appropriate, as Your Honor just pointed out, to decide on a motion to dismiss. And even if this were a regular litigant, not Donald Trump, who Justice Engoron has sanctioned multiple times for fraud in discovery, even if this were a regular litigant, those would be improper on a motion to dismiss. On top of that, what did Robert Trump testify at his deposition? He testified that he managed to get volume discounts, that the reason why they were getting this money and the prices were so low was because of volume discounts, not because, as the New York Times concluded, they were completely fake transactions done to siphon money away from Mary and her brother. None of this, Your Honors, however, is appropriate on a motion to dismiss, and this case should have been put forward for discovery, and as Your Honor pointed out, it should have been decided on summary judgment. Second of all, remembering the question you asked Justice Scarpula earlier, there is a carve-out in the release. The carve-out in the release deals with the sale of her interests in these entities. If you're going to read that broadly, then you got to read the carve-out broadly. And if you're going to read the carve-out broadly, excluding the agreement in which she transferred those interests, then they should not be excluded under this release. Third, this court has been very third. Justice Reed applied the wrong standard. Whatever Your Honors decide, you have to agree that it wasn't the right standard. He applied the standard of fraud and duress for getting out of the entire release. That's not the standard that applied. That's what Breitel said in Mangini, and it's what you have said in numerous cases citing Centro and Mangini. And finally, Your Honors, again, you have to please keep into account the procedural status of this case. They want to have it both ways. They want to say that all these things apply, and then they want to argue the facts on a motion to dismiss. Mary Trump is entitled to discovery. She's entitled to figure out what really happened here. She had a proverbial gun to her head when she signed this agreement, and under Centro and Mangini, it should go to discovery, as this court has said multiple times. Thank you, Your Honors.
Thank you. Thank you all. Manfredonia versus 750 Astor.
Good afternoon, Your Honors. May it please the court. Dara Rosenbaum from Rosenbaum and Taylor for the appellant 750 Astor. It is undisputed that Mr. Manfredonia, the plaintiff, was at my client's building. What is wholly unclear and what should have precluded entry of summary judgment in favor of plaintiff on his Labor Law 240 claim is why he was there. Was he there for maintenance or repair or something else? Respectfully, plaintiff did not make out a prima facie case as to entitlement for summary judgment on 240.
The plaintiff says that he was there because he got a call that wasn't in one of the months that he usually does maintenance work. And when he went there, he discovered that what needed to be done was a repair of a pipe because it was tilted in the wrong direction, and his intention was to replace this pipe. Repair and replacement, is that not within 240 here? And obviously it's a case with a ladder, and he used the only ladder and he fell. But I think the heart of this is really as to what the work was that he was doing.
And I think the heart of it goes to the conflict.
And what do you have? What does the defendant have in contradiction of
There's
that?
no record from his employer, his father's the owner of the employer. There's no record from the employer as to what he was there to do. He's there on April 26, 2013. The regular maintenance is May 2013, and the father specifically testified that, yes, sometimes we go earlier or sometimes we go later depending on access. There's no indication that anybody else was ever sent to the job site to do this work that plaintiff testifies was so dire and so critical to the functioning of the HVAC. The only work that is done during the regular course of the summer startup in May of 2013. So the inherent conflict between what plaintiff testified, what his father testified, and what the records do and do not show should have precluded entry of summary judgment.
What inherent, what are you talking about? The father said he went for the repairs. He said he went for the repairs. And they both explained why there was no ticket. What is inherently inconsistent?
The father specifically testified that had another worker been sent back to the site to do the work that the plaintiff was not able to do because of the accident, there would have been a work ticket. There's no work ticket.
But he said there was no work ticket because the son was injured, right? He explained
No, I understand that, but the second, if there had been somebody sent back after April 26, 2013 to do the work that the
Well, there
plaintiff
could have been
couldn't
someone
do.
sent from a different company. I mean, that's neither here nor there. So
There's no
isn't-
indication that there's any other company that was contracted.
Well, that's
or ever sent to
exactly
the site.
right. That's complete supposition. We're not talking about what might have happened. He testified this is why there was no ticket. One, that his son was sent for repairs, and two, here's why there wasn't a ticket. So let's assume that we agree, we think that that's enough to raise a prima facie. What have you put in opposition to that?
There is, when there's no record, the records are beautiful, and the Falk has fantastic records, except for that day. There's literally nothing that says why he was sent there, and there's nobody who goes back to do the work he was supposed to have done. It's not repair, he's not there to repair something. He's there to do, at best, ordinary maintenance, but there's certainly a question of fact on it.
Thank you.
May it please the court, I'm here on behalf of the Jewish Board. There was a maintenance agreement for them to do work, and the work that was done pursuant to that maintenance agreement was not charged or charged pursuant to the agreement on a monthly or once every 4 months. The work that he said he was there to do that day, he says, is a repair. He said that the HVA system would not be working if he did not do that work.
Well, he said it was a repair, but that's when he first went up. Then when he
Correct.
discovered what the issue was,
he
went down to get tools to replace it.
Right, and the testimony is he did not do that work that day. There is no other work tickets that were generated by this company showing that they went and did the work afterwards. The plaintiff's
And
father
what is that-
testified.
What is that? What are you saying that goes to?
That the work that the plaintiff said he was going to do was, I don't know. Was he not telling
Well,
the truth?
there's
Was he trying to get a
no-
labor law case here? I
There's-
don't know that.
There's nothing done. So
Right, no
what does
work
that
is
say
done.
about the company? They were
So
called,
then
may I, please? What does that say about the company where no work at all is done? There's no ticket from anyone. That's neither here nor there. As my colleague has already said, it's supposition. So the question is, what existed, what do we know, and what have you produced concretely in opposition to it?
Again, the plaintiff said this system would not work without this repair. The repair is not done that day, and the next time the company does show up, they don't do that repair. They do regular maintenance work a month later. So there is no repair work documented anywhere in this case besides the plaintiff saying that's what I was gonna do, and the machine would not work if it wasn't done.
So there's only, so are you saying that they had to hire a different company, or they didn't hire a different
No,
company?
the company
or
that they used would be Falk.
They did it a month later. But the fact that there is nothing there doesn't mean another company didn't come. It doesn't mean anything, because it's the absence of evidence, which we can't really look to when we have a record and nothing in opposition to what one party is saying.
Well, there was no subsequent work until Falk came back and did their normal, regular inspection and maintenance work.
Did you put in an affidavit from any of the defendants saying, I called them for routine maintenance?
No, the routine maintenance.
Did anyone say that on
No.
on the defendant's side? This was routine maintenance?
No, they would
The
come
owner
and.
didn't say it, the company didn't say it, no one said that, correct?
Correct.
So the only evidence we have is that this wasn't, the only evidence we have is that this wasn't, correct?
No, the evidence we have is a ticket done, the next ticket when they came back to do the work, they did maintenance work. There was no repair work being done when they returned to the site. The plaintiff's father testified that if they came back to do the work, they would have had a ticket. That's
Thank you.
Good afternoon, Your Honors. My name is Jonathan Edelstein. I represent the plaintiff respondent, Salvatore Manfredonia.
What does it mean that no one ever came back except a month later from the company that the plaintiff?
Your Honor, the defendants presented no evidence of what that would mean.
So it means nothing?
Well, what it means is that the plaintiff came to conduct repairs on the air conditioner drain in April at a time when the air conditioner wouldn't have been on. That 1 month later, there was a so-called summer startup. That was provided for in the service contract, but it was separate from routine maintenance. It's unclear what was done and what was not done in the summer startup, but certainly this problem, wouldn't have eventuated at a point when the air conditioner was not on. It's also possible that, whoever did the summer startup might have disagreed with what the plaintiff found.
Mike, is it relevant to what happened on the day of the accident?
It's not, Judge. It's not, because well, first of all, also, the defendants have argued that the plaintiff testified that this was some kind of imminent issue where if he didn't fix it right away, the the system was gonna collapse. What he said was that there's a danger of a backup or a leak if this is not fixed. He didn't say there's certain to be some kind of catastrophic consequences.
And on this record, sir, on this record, when the father and the plaintiff both submitted affidavits describing the nature of the work as being a repair and not routine maintenance, there was nothing from the defense side to counter the sworn statement based on personal knowledge and experience.
Absolutely, Judge. And even if the defendants had not had a witness with personal knowledge, they could have consulted with an expert.
And this particular type of repair is not one of the types of maintenance item that was enumerated in the agreement on the record of page 702, correct?
Absolutely, Judge. The record, the service contract did not list repair of the drain pipe as routine maintenance. And moreover, the work tickets that were generated for routine maintenance involved cleaning the drain or checking it for clogs, but not repairing the pipes. That was never done as part of routine maintenance. There's not a single work ticket showing that was done as part of routine maintenance.
For labor law 240 sub 1 purposes, what distinguishes repairs on the one hand from routine maintenance on the other?
Well, the case law, both that the defendants have cited and that we have cited, refers to replacement of parts that are expected to require replacement in the course of ordinary wear and tear. The plaintiff and his father both attested that this was not such a component. The defendants presented no evidence that this was such a component. They didn't present any indication whatsoever that these drain pipes would be routinely replaced in the course of ordinary wear and tear. They didn't show that this is the sort of work that was in the category of routine maintenance. And I would also point out that this court in the Soriano case said that in that case, a glazier with 30 years of experience was very qualified to testify about what was routine maintenance and what wasn't. In this case, Mr. Manfredonia Sr. had 40 years of experience. And he was very clear, very unequivocal, that this was not routine maintenance. Under the Soriano case, he was absolutely qualified to offer that opinion. And again, even if the defendants didn't have a witness with personal knowledge, there was nothing to stop them from consulting with an HVAC expert if this was indeed a routine repair. The fact that the work was not actually done, that the accident occurred when Mr. Manfredonia Jr. was preparing to do the work, that's of no moment. That's the Saint versus Syracuse supply case cited in our brief, saying that if an accident occurred while a worker is preparing to do covered work, that's considered covered work. And to the extent that no work ticket was done that day, not only was that explained, but there was also testimony that work tickets are generated for both routine maintenance and repairs, so the absence of a work ticket doesn't cut one way or the other. This isn't a case where work tickets would only be done for non-routine things. The fact that there was no work ticket doesn't move the scale in either direction. So ultimately, this is a case where the plaintiff presented ample evidence, not only his testimony and his father's, but corroboration in the service agreement and in the various maintenance tickets that were done over time, that this was not a routine repair he was engaged in, and the defendants offered nothing to rebut that. No witness, no document, no expert affidavit, nothing.
Is just one, not the only, but one reasonable inference to be drawn from the absence of the work ticket documenting what was done on a given day, Is one reasonable inference from that that the work was not important, that was not necessary, did not represent a repair within the meaning of Labor Law 240?
Well, not on this record, Your Honor, because as mentioned, there was testimony that work tickets are generated by Falk, both for the important stuff and the routine stuff. So if the absence of a work ticket or the presence of a work ticket doesn't affect that one way or another, I mean, and certainly the fact that a work ticket was not done that day, it was because Mr. Manfredonia Jr. fell off a ladder. I mean, that's something that would occupy his father's attention no matter what he was there to do.
Thank you.
I see I'm out of time, so I'll rest on the briefs, Your Honors.
Your Honor, the fact that there are work tickets for repair and maintenance doesn't change the fact that there are charges for repair, but not charges for maintenance. And there's no separate charge for any repair work done the next time that Falk is there in May of 2013. We're not arguing that he wasn't a covered person because the work hadn't yet been done. We're arguing that he wasn't a covered person because he wasn't doing repair work because that repair work was never done. Plaintiff's testimony makes this problem grave. He doesn't say, respectfully, that there could have been a problem. He says, I had to fix a malfunction that affected the operability of the whole AC unit. It could not have been left because the water would have backed up into the unit. So this is a critical piece of repair that he's saying needed to be done that the records show was never done, was never separately charged for. There was simply a summer startup in May of 2013, no charge for repair, no evidence that there was ever a repair, which to me at least creates an issue of fact as to what he was supposed to be doing there that day.
Thank you.
I would just like to emphasize, this is a sole witness accident. The only person that's telling us what was occurring that day was the plaintiff himself. The plaintiff's father was not a witness to the condition, so it's just the plaintiff. And I believe that the work records that we have provided, the fact that there was no record of why he was there that day, either repair or maintenance, that the follow-up work that was done a month later was solely maintenance, at least raises a credibility issue that should have required a denial of the motion for summary judgment.
Thank you.
Thank you, Your Honors.
Houseman versus Bauman.
May it please the Court, Your Honors. I'm Albert Chang, appearing on behalf of the appellants, two Bear shareholders, Ms. Hausman and Mr. Catan. Together with Ms. Hausman, Mr. Catan, who resides in New York, brought this shareholder derivative action on behalf of Bear, challenging Bear's acquisition of Monsanto, which has been known to be the worst acquisition in history. I want to begin my argument today by informing the Court that just 10 days ago, a federal court certified a class of Bear shareholders in a securities fraud class action, upholding their right to sue in federal court for securities fraud arising from some of the same facts giving rise to this shareholder derivative action. That decision has been reported in 2023 U.S. District Lexus 88178. The relevance of that federal class action to this appeal is that this derivative action is part of the coin of that class action. In this shareholder derivative action on behalf of Bear, we allege that Bear was badly damaged by some of the same misconduct alleged in the securities fraud class action. In fact, we pleaded the existence of that class action in our derivative complaint here, and that is on page 319 of the record. Yet the trial court here dismissed our case based on forum nonconvenience, while the federal district court has certified the securities class action to go forward in the United States. But there's no reason why these two cases could not be litigated in a parallel fashion here in the courts in the United States. thus as Congress created subject matter jurisdiction over securities class actions involving foreign corporations selling securities in the United States, the New York legislature enacted Section 626 and Section 1319 of the Business Corporation Law.
So, counsel, let me ask you, so the trial court dismissed on the basis of the internal affairs doctrine, right?
That's one of the
Right.
bases.
All right,
that
let's
trial
assume
court
that's
dismissed.
one. So that doesn't, I mean, the fact that a federal class action was certified would not vitiate the internal affairs doctrine, right?
That's correct.
So why don't you address your comments to that doctrine?
Sure. The internal affairs doctrine argument goes twofold. We raised two independent grounds for reversal of the trial court's application of German law with regard to the issue of the shareholders' derivative standing to sue. This appeal is about New York resident shareholders' access to New York courts to bring derivative claims on behalf of foreign corporations doing business in New York. The trial court was wrong in applying the procedural requirements of German law to this case. We ask that the court reverse the trial court's decision on two independent grounds. Both grounds are straightforward. The first ground is stare decisis. Under the Court of Appeals decision in Davis and the Second Department's decision in HSBC, this court should find that Section 148 of the German Stock Corporation Act is procedural. And
Well, what about our decision in Lerner and Hart, in which we found it substantive, not procedural? Right? We're in the First Department, and we have two cases in which we found that the internal affairs law doctrine is substantive, not procedural. So what do you have to say about our law?
We agree wholeheartedly with the notion that the internal affairs doctrine governs substantive issues. We agree wholeheartedly with Hart and Lerner line of cases, except in the context of 1319. Except in that context, when the New York legislature has decided that when a shareholder brings an action.
So it's your position that 1319 overrules or all the line of cases that deals with internal affairs doctrine?
That is imprecise. It is our position.
And we've never held that, right?
Correct. What we are submitting is that when the legislature has spoken, that the following provisions, including Section 626, applies in an action, in a derivative action involving foreign corporations doing business in New York, that legislative mandate trumps the internal affairs doctrine. And we hasten to note, Lerner and Hart has nothing to do with shareholder standing to sue. Lerner and Hart dealt with demand refuse cases where the rights to discovery were invoked. But here we have a different case. And this court in Colligan says exactly that. Colligan says that when a shareholder brings a derivative lawsuit on behalf of a foreign corporation doing business in New York, Section 626 controls. Colligan is this court's on-point precedent, and Colligan is binding.
Well, what about Eccles, New Greenwich? Those are all post-Culligan cases, right? Where
Yes.
we held the exact opposite.
Not in the context of 1319, Your Honor. Once 1319, the argument under 1319 is raised, this court has never held that the internal affairs doctrine trumps 1319. And it is and Colligan says exactly the opposite. And Colligan says, we agree with this statement that Colligan does not overrule the line of precedent upholding the internal affairs doctrine, but only in the context when Section 1319 is absent. In this case, we have Section 1319, and under Section 1319, the New York legislature made a reasoned judgment to protect shareholders on the one hand, and protect the management of foreign corporations doing business in New York's right to run their corporation. And that recent judgment cuts right in the middle, permitting all holders of beneficial interest of a corporation to bring a derivative lawsuit on behalf.
So you're saying that you think that one person who holds one share, who lives in New York, can sue in New York about internal affairs of a corporation that happen halfway around the world and affect mostly a company that's halfway around the world? If I hold one share in New York?
That's what Section 626 says. But we hasten to note that this is not.
You think that's what 626 says?
626 says exactly that. All holders of beneficial interest of a corporation may bring a derivative lawsuit recovering damages on behalf of that corporation. But, Your Honor, this
No,
is
that's right. But that's separate from saying where they can bring the action, right?
they say that an action may be brought.
Sure, you can go, bring an action, but it doesn't say it has to be brought in New York.
There's zero doubt that Section 626 applies to New York courts. That's what 626 says. That's what 1319 says when it says that Section 626 applies to foreign corporations doing business in New York. But, Your Honor, this case is not about something that happened across the globe. This case has everything to do with New York. The investment banks for the acquisition were here in New York. The due diligence was done here in New York. Counsel for both Monsanto and Bayer were here in New York. Bayer's executive team negotiated the final terms of the acquisition at a restaurant in September 2016 right here in New York. In fact, the closing happens just in New York, in Sullivan and Cromwell's office.
No, I'm not doubting, we're not talking about foreign nouns. We're talking about who's got the bigger interest in how this corporation runs. The place where the corporation is functioning and its board of directors is, and the laws that apply to that, or New York State. And what you're telling me is one person with one share in New York State makes New York have a better, more compelling interest than the company's headquarters or where it's incorporated and the laws of that jurisdiction. That's what I'm having a hard time with.
The laws of Germany applies to this case on the substantive claims.
So then, under German law, let's assume we agree with that. Did you do proper demand on the board?
We did not make a demand on the board under German law.
If German law applies and you didn't do proper demand, if you didn't make, I shouldn't say do, you didn't make a proper demand, you have no standing, correct?
That's incorrect because Section 626 says that we have standing, and Section 1319 commands that this court applies Section 626 in our case. We will reserve my time. Thank you, Your Honors.
May it please the court, William Savitt from Wachtell Lipton for the Bayer defense.
So what do you say to that? Why are we not applying New York's
626 and 1319?
The internal affairs doctrine is one that is of great and long lineage. It's existed for over 100 years. It articulates a simple principle. That principle is that the law that governs the internal affairs of corporations must be governed by the state or jurisdiction of incorporation. It's a bedrock, basic rule of corporate law. It's been articulated by...
And why doesn't 626 and 1319 change that bedrock principle?
The reason is that there are a lot of reasons why, Justice Scarpool. The first one is when one reads the statutes themselves, they don't say that. Section 1319, it's in Article 13 of the BCL, which governs foreign corporations, it says only that 626 applies to foreign corporations to the extent provided therein, provided also that they do business within the statutory meaning in New York. That's all 1319 says. 626 says only that a derivative action may be brought in New York State. That's what these statutes say. They say nothing else. None of them say anything about the standing requirements that will be applicable for foreign law derivative actions.
So we could have jurisdiction to hear it, but ultimately in applying the substantive law of Germany, they're out of the box.
Precisely correct. In some sense, one can think of this as taking away the claim that Supreme Court lacks subject matter jurisdiction over a derivative action, but it doesn't have anything to do with standing. It doesn't have anything to do with what the substantive requirements might be for advancing such a claim, which is the issue that was presented below and is now before this court. It is the issue respecting which my good adversary, which is to overthrow 100 years of established precedent in all 4 departments, in all 50 states, and in well-nigh every country on the planet.
What
So
about
the fact that, go ahead.
What about Culligan?
Well, plaintiff's only answer to all of this authority is the Culligan case.
Well, we can't blame him for that.
I can't blame that, Your Honor, fair enough. As the City of Aventura case in Supreme Court observed, Culligan was a narrow case. It concerned the regulation of conduct within New York. It did not purport to alter any existing law. That's clear from its face. No court has ever read Culligan as holding that New York law governs the matter of derivative standing for foreign corporations. It's never been held. And at page 21 and 22 of our brief, we cite case after case after case that specifically reject precisely the 626 argument that my friend makes, and that's just the beginning. Because even after Culligan, over and over again, this court has continued to apply to foreign derivative standing cases, foreign derivative standing rules consistent with the internal affairs doctrine. Half a dozen of these, Your Honors, are collected at page 24 of our brief. There are more since. As Justice Singh put it in the Blau case, had this court wanted in Culligan to change the clear precedents from Hart to Lerner, it most assuredly would have said just that and why. But it didn't. And it didn't because that would have worked a policy and precedential revolution that case surely did not intend to do. Any other result, to be clear, would upend not only lots and lots of precedent, but would leave New York as essentially the only jurisdiction in the country to disregard foreign law on the matter of derivative standing. Foreign companies would be subject to conflicting standards and conflicting rules, giving rise to the risk of inconsistent judgments and standards, precisely the outcome that the internal affairs doctrine, recognized by our Court of Appeals, by the United States Supreme Court, is designed to avoid. And for that reason—
So forgive me for asking again, because you started off saying it. What is it that you believe that 1319 and 626 stand for in the language that says it shall apply to foreign?
Thank you, Justice Renwick. The 1319 is at the tail end of Article 13 of the BCL, and what it does is it lists those provisions that are not cataloged in 1319 that may have applicability to foreign corporations. That's its office. One of those is Section 626. It actually cabins 626 because it says that to qualify to a foreign corporation, there must be a finding that the foreign corporation does business in New York. And then when you turn to 626, it provides the basic rule that subject to the rules of standing, derivative lawsuits may be heard in Supreme Court. And that is what 1319, Your Honor, and 626 appear to be doing. What's very difficult to conceive, and what no court has ever held, is that Culligan or those statutes were designed to undermine the rule of the internal affairs doctrine. And just to put this in a little perspective, if plaintiff's argument is correct about the internal affairs doctrine, the Hart decision by the Court of Appeals, it would make no sense. Because that court was asking, well, what are the derivative standing rules? And it looked abroad. Why would it have done that? It would have been contrary to statute. This court's decision in Lerner would have made no sense. This court's decision in Wandel would make no sense. This court's recent decision in the AEA Middle Market against Marblegate case, it would make no sense. It would make a mash and a hash of the law. Just a word, Your Honors, on the doing business prong of 1319 as well, because it is relevant. 1301B of the BCL makes clear that if Bayer AG, The German corporation isn't doing business in New York. That's a further reason it doesn't apply. And the kinds of things that are alleged here, a few business meetings, defending litigation, holding bank accounts, doesn't cut it. It's essentially a general jurisdiction requirement, and there has not been adequate allegations to establish it. Plaintiff made brief reference to the forum nonconvenience issue, and I'll mention that as well because it was an independent alternative grounds for dismissal and it ought to be affirmed. The boiled down question under Section 327, as the Court of Appeals put it in Pahlavi, is whether the lawsuit belongs in this court or should be adjudicated elsewhere. I should add that there is a federal securities law case being brought subject to the federal securities statutes that is a direct claim on behalf of a U.S. citizen, completely different than a derivative claim being brought on behalf of a German corporation, which was what this case is entirely of no moment, because the relevant plaintiff in this case is Bayer AG. It's a German corporation subject to German law. Nothing to do with an individual American investor who may have a claim under the federal securities laws.
Well, the reasons underlying the internal affairs doctrine would seem to cut against would support a forum nonconvenience dismissal.
Entirely, Your Honor, because German law governs this case, distinct from a securities law case, and that's essentially the first factor. There's no question substantive German law controls. The German law of fiduciary duty controls. All the witnesses here would have to travel from Germany to appear in Supreme Court downtown. All of the evidence would have to be brought over from Europe subject to data privacy laws. The actions here didn't take place in New York, they took place in Europe. The negotiations didn't take place in here, they took place in Europe. The relevant question is, where was the decision made to enter into this merger agreement? Because my adversary says it was a breach. It happened in Germany.
Thank you.
It all happened in Germany. Your Honors, thank you very much.
Good afternoon, and may it please the court. Lara Samet-Buchwald of Davis Polk and Wardwell on behalf of Bank of America Corporation and B of A Securities, Inc. I just want to make a few brief points on behalf of the bank defendants who largely, I think, share the views of the Bayer defendants with respect to the forum nonconvenience arguments. There are two additional points that I just briefly wanted to address. The first is with respect to the standard of review, and there seems to be some dispute in the papers. We think the Court of Appeals is quite clear in both Pahlavi from 1984 as well as the State of Kiner from 2021 that this is an abuse of discretion standard. And in the State of Kiner, they go further to say that if the court below considers the relevant factors in evaluating the motion, there has been no abuse of discretion. That's the end of the question. And what's quite clear, what the motion court did here was it evaluated Pahlavi, it applied the test in Pahlavi, it then evaluated and applied 5 different decisions of this court. And so for those reasons, there has been no abuse of discretion, and the decision should stand. With respect to the actual factors themselves, and if this court were to weigh the forum non-factors themselves, again, as counsel over here has said, it's quite clear that they all point in favor and counsel in favor of a forum nonconvenience dismissal. The witnesses are in Germany, the documents are in Germany, the claims arise under German law. There is an adequate forum in Germany where right now there are pending shareholder derivative claims that are proceeding. To just address 2 points that were raised earlier, counsel for appellant said that the investment banks were in New York and the diligence was in New York. Frankly, those are conclusorily pleaded. If you look at the record, it is quite clear that with respect to B of A in particular, the banks that were engaged to due diligence were foreign entities. It was a UK bank with a German branch that was engaged to do the work. It was not the affiliates that they happened to name in this case. But in any event, putting aside the question of which entity was engaged, you still have the exact same analysis that the witnesses are abroad, that the documents are abroad, that the claims arise under German law.
Thank you.
Thank you.
Thank you, Your Honors. With regard to forum nonconvenience, a New York plaintiff has a presumptive entitlement to bring a lawsuit in New York. To overcome that presumptive entitlement, defendants must come up with competent evidence. There's no competent evidence here. The only thing is counsel's statement that it's difficult to litigate a case in New York.
Counsel, how do you address the city of Aventura case that counsel brought up. How do you address that case?
City of Aventura obviously is a trial court decision, and City of Aventura was wrong by way of failing to follow Colligan. It is wrong to say that Colligan did not rule that Section 1319 applies. As a result, Section 626 applies. It is wrong to say that Section 1319 is really only a jurisdictional conferring provision. Interpreting 1319 as a jurisdictional conferring provision would violate a canon of statutory interpretation because Section 626 has already done that. Section 1319, it is a policy decision made by the New York legislature to endorse and to codify 200 years of history of New York courts asserting subject matter jurisdiction over shareholder derivative lawsuits. Is a policy choice that has already made by the New York legislature. New York courts must follow it. We ask for no revolution. We ask for a straight interpretation of statute. 1319 says what it says. Section 626 says what it says, in addition to saying that an action may be brought on behalf of a corporation, foreign and domestic. Section 626A also has a requirement for what qualifies as a shareholder who has standing to sue. This court is duty-bound to apply Colligan. This court is duty-bound to apply Section 1319.
Sir, is your friend, are your friend's concerns regarding disturbing comedy and making New York an outlier, are they valid concerns if we give these statutes the effect you're asking us to give them?
Not at all, Your Honor. Every jurisdiction has a similar law like Section 626. For example, the Federal Rule of Civil Procedure is drafted just like Section 626. You just need to be a shareholder who has a beneficial interest in the corporation in order to bring a lawsuit. We ask for no revolution here. Section 1319, in Section 1319, the legislature has made a policy decision. In Colligan, this court has decided this on-point issue. Defendants do not ask that this court overrule Colligan. Actually, it is wrong to overrule any precedent when the president interprets a statute, and that's a common law of this state. We ask that you reverse and remand.
Thank you. Thank you all.
Thank you.
Trevino versus Prey, both appeals, 05404 and 05323.
Do I just start?
Just a moment. So, Ms. Trevino, I understand that you're pro se. You may either, you have 4 minutes, and you can tell me what it is, tell the panel of judges what it is that you want us to do, if that's the simpler way for you to proceed, and we'll ask questions if we need to.
Thank you so much. I appreciate it, Your Honor. I actually wrote everything down. If it exceeds a little bit of 4 minutes, would it be possible to just finish?
We'll see.
Okay, thank you.
Maybe we should, I'll start by asking you. You've asked here for complete custody. You've asked here for attorney's fees. You received custody here in this case. There was no question about that. But with regard to attorney's fees, you're pro se. So what would the attorney's fees go to here?
Well, there are 2 cases, Your Honor. The first case, I did have an attorney, and there were more than $70,000 of attorney fees that took place, as my brief states and as all the records show, because respondent refused to acknowledge paternity, despite a paternity test confirmed him to be the father of the child with over 99.9% certainty. The reason why we're here today, even though we already have paternity established custody, is because for over 2.5 years, respondent used frivolous litigation against me. I have everything written down if that makes it a little bit more clear. I hope that's
Well, we already have your appeal. We have your brief.
correct. But I do have an argument. I'll read it, and if you have any questions, please feel free to let me know. I come here today covered in wounds that are not visible to the eye. Nevertheless, wounds that compromise my physical and mental health, my safety, my life, as well as my child's, and which will carry lifelong repercussions. They were deliberately inflicted by a man who lied to me about his intentions, a man who took advantage of my love and trust for him, a man who abused the trust and did not respect my explicit terms of consent about wearing protection when engaging in acts of physical intimacy, a man whose sole selfishness and irresponsibility resulted in him imposing a pregnancy on me, a man who then insisted on me having an abortion, a man who heartlessly claimed he would give up the child for adoption if he were to have custody of the child, a man who deliberately abandoned me and his unborn child when I was 7 weeks pregnant, a man who refused to acknowledge paternity despite a certified paternity test which met all the accreditations required by law, confirmed him to be the father of the child with over 99.9% certainty, a man who left me alone with no friends or family around to give birth to his child during the highest peak of the pandemic in New York City, where over 150,000 COVID cases had been reported, a man who deprived me of the peace of mind I needed and deserved by blocking contact, sending litigious threats, and demanding a second paternity test for absolutely no reason, but to shirk his parental responsibilities and inflict significant suffering upon me, as I feared for my life and my child's since I was about to go into labor in one of the city's COVID-infested hospitals, while the city was in a state of emergency, and bodies were being carried out by forklifts into refrigerated trucks just a few blocks from my home. A man who refused to discuss matters outside of the court despite my countless attempts to do so to try and resolve matters amicably, resulting in over $70,000 of counsel fees even before proceedings began. A man who forced matters to court without justification and intentionally dragged them for over 2.5 years to deliberately impose harm on me and our child as his malicious vendetta for not having an abortion inflicted on me such an indescribable pain and suffering which pushed me to suicide. I am not sure if such individual can truly ever be called a man, but it was this individual's lies that started it all, and it's
Thank
his...
you. You have 2 minutes on the other end. You can finish then, but you are an attorney here in New York?
Am I an attorney in New York?
Are you an admitted attorney here in New York?
No, Your Honor, I'm a
Okay,
pro
I
se
just
litigant.
wanted to clarify. Thank you. You'll have 2 minutes.
Okay.
At the end, after counsel speaks, then you'll have 2 minutes to finish.
Oh, so I'm
That's right.
Good afternoon, Your Honors. My name is Franklin Prey. I'm the pro se respondent in this case.
Are you're pro se as well?
Yes, I am, Your Honor. I'm happy to answer any questions about the justification of why I feel this appeal should be dismissed, but I can also focus on the weight of the evidence. The appellant alleges that the lower court did not consider all of appellant's filings in its decision, and she also alleges that the trial court failed to analyze those filings correctly. In my perspective,
I just want to ask you, the first petition, were you both represented, correct?
That is correct.
And then the plaintiff here withdrew that petition.
That is correct.
So there's no first action pending anymore.
That is correct,
Okay.
Your Honor.
So that would moot the issue of attorney's fees then?
So what gave rise to why we are here today is that I filed for attorney's fees against the appellant. The lower court ruled against awarding me attorney's fees in that particular case. But that's when the litigation against me by appellant started around, and the issues at hand are really, she would like to have my former attorney disbarred. She would like to have her license, her law license, her license to practice law withdrawn. She would like for me to undergo a psychological treatment. and she would also like an order of protection in her favor.
In fairness, sir, you have, based on the order that's pretty much immutable, Ms. Trevino has complete custody of the child.
That is correct.
You have absolutely no role to play in any way, shape, or form with that child, correct?
That is correct.
Nothing, no visitation, no parenting.
No parenting at this
So
time.
that your psychological well-being, if anything, is absolutely irrelevant.
That is correct.
Because you have no role to play with the child.
That is correct, Your Honor.
You said at this time, right now the order is final. It says no visitation and no custody.
That is correct. At this point, it is, yes. But I reserve the right to revisit that in the future.
And what was the basis for the mother's request for you to seek therapy or undergo a mental health evaluation? What was the basis for that?
I think you heard what she said earlier and what she alleges. This is clearly outside the record that was submitted to you. If you go through the record, there's really no evidence of any of the allegations that she has brought up. And from my perspective, that's why the lower court ruled in the way it did.
And it's fair to say that you both received what you wanted. The mother custody and you didn't want visitation. You both got what you wanted.
That is correct. And the issue should have been settled at that time.
Thank you. Okay, ma'am, you have 2 minutes.
Your Honor, I would like to address that information is not correct. The order to show cause that he submitted was to specifically request for counsel fees for himself and impose sanctions upon me, claiming that all the documents that I made for paternity, custody, and child support were all meant to, and I quote, harass and embarrass him.
But in any event, you during this period didn't have an attorney, am I right?
Correct.
And the court gave attorney's fees neither to you nor to...
The court analyzed my conduct, all my filings, to determine my intention and motive of my filings.
And you were not charged with having to pay his attorney's fees, right?
Correct, because the court understood that everything that I did was pretty much standard practice, especially as a pro se litigant. However...
And there was no award of sanctions awarded to Mr. Prey, correct? There were no sanctions.
Against
In other words,
you.
there's no finding
There
that
was
you
nothing-
were frivolous.
Correct. There was, after analyzing my conduct and analyzing all the timeline of events that are all submitted in my brief and in my response, the court did conclude that none of my behavior or actions were frivolous. However, the court did not address my requested relief that I submitted in my response papers to his order to show cause. One of the big things that I realized as a pro se litigant is that I am not fully familiar with the legal procedure. I did not know at the time that I needed to file a cross motion to make such a request. Because I was not aware of that, when the court issued the first order, they did not address any of my requested relief. They only addressed respondents. So when I reached out to the Supreme Court again, multiple times via correspondence, asking for a response to my requested relief, I did not receive any information. That's when I called the court. That's when they told me I had to do a cross motion. But because an order was already issued, I then had to file a motion or an order to show cause. So that's what I did. I submitted a new order to show cause, and the court's response was to have a hearing that within less than 5 minutes, they dismissed all my requests. They dismissed my orders to show cause, and it was very clear that they did not go over all the evidence that I presented to take into consideration my requested relief. Just because I did not act frivolously, it does not mean that the opposing party did not do that. I have evidence, like recordings, very straightforward recordings between me and his counsel, that show that they're the ones who refused to sign a basic child custody agreement. But in their order to show cause, they say that it was me, so that I would have to pay their legal fees and to try and give me sanctions. They deliberately committed frivolous litigation for 2.5 years, multiple acts of perjury, and that is why I'm requesting sanctions. And a sanction can take place in the form of legal fees, even though I'm a pro se litigant. And I did cite the law and the case law in my brief.
Thank you.
Thank you.
Thank you both. People versus Melinda Ratliff.
May it please the court, Abigail Everett for Appellate Melinda Ratliff, excuse me. The trial judge denied the defense lawyer's request for a judicial diversion evaluation on two grounds. One, that it was already the eve of trial, and two, that it would be frivolous because Ms. Ratliff was not alleging an ongoing dependency on prescription drugs. This was wrong for two reasons.
Didn't the attorney below acknowledge on the record that there was no drug dependency issue?
What he acknowledged was there was no current drug dependency. But if you look at the statute CPL 21605, the standard the legislature has put in place is whether or not there was a problem with drugs at the time of the crime that played a role in the commission of the crime. That's really why the legislature provided a possibility of diversion so that people could get have an acknowledgement that they wouldn't have to either serve prison time or even in some cases have the charges dismissed if the drug use really played a role in the commission of the crime. Now, the judge said this is the eve of trial, it's too late, you should have done this at arraignment. But if you look at the statute, you can see that generally in the course of diversion, there's contemplated that somebody's going to plead guilty. So of course, the defense lawyer would want to explore the full case possibly before engaging in a request for an evaluation of diversion. So,
What evidence was there that she had a history? I mean, he
Okay.
said, okay, I wasn't clear that she had mentioned it or said it, except
Right.
for when he was asking her. Anyway, I think.
Well, if you look at the minutes of April 25th, when this was litigated, you can see that the judge said, haven't we gone through this already? She didn't have a current issue. So obviously there had been some preliminary discussion about this that we aren't privy to on this record. But then the defense lawyer asks for a moment and he's consulting. And at that point, the judge says, oh, it doesn't matter. I'm not going to send her for diversion at this point. So while the record does not fully explain the extent of her reliance on prescription drugs, you do see in this record that the judge stopped the process from going forward for impermissible reasons. So while I acknowledge that the record is a little sketchy on the nature exactly at this point of what the drug dependency was, I think that's because of the way the judge handled the request. We know on this record that while she was out on bail and living in Ohio, that she was arrested and she had to do drug treatment and community service as a result of that
I'm sorry,
arrest.
when did you say that was?
I believe it was August 2016. She was arrested on this case in 2015. This colloquy asking for diversion is in April. So that in the interim between the time of her arrest and the request for diversion, she was arrested for drug possession and she had to do treatment, which is very relevant. And the defense lawyer, when he brings this up on the record, says something, it's come to my attention that my client has a history of dependence on prescription drugs.
Counsel, if I may, what, if any, information did counsel present as to the prescription use and how that was a contributing factor to, to the offense?
Right, Your Honor, on this record, he did not present particularly much at all. And what I'm trying to suggest is in part because we don't have an adequate record. The judge acknowledged there was a prior discussion. The court enlarged the record. We have the minutes of the prior dates, but there is no discussion.
So didn't counsel say at the time that day that his client did not have a drug issue?
I'm trying to focus on the word. He said she doesn't have a quote-unquote present problem. He did not admit that she had no prescription drug abuse.
He said it resolved 6 months prior, I think is what he said.
Right, so why would she go into diversion for drug use when he said she's not currently having a drug problem?
First of all, that's her personal perception, and it very well may be that if she was evaluated, it was confirmed.
You're saying that the judge can't depend on what the lawyer says about his client?
I think that if there's part of what's going on, you could have a follow-up of whether or not, I do see my white lights on.
I just have one other question. This was
Yeah.
at the eve of trial, you said?
Well, the judge used that phrase, eve of trial, as in fact, it was several more months before the trial occurred, but I would argue that the statute says specifically you can make a request for diversion at any time before the beginning of trial. So it's really irrelevant that even if it were the eve of trial, that is not a factor that the judge should have been considering.
So your point is that there should have been an adjournment to discover more about this
Right, the defense lawyer is
But if
asking for an evaluation.
But if the trial didn't happen, so the defense lawyer has to get the permission of the court to evaluate his client? for this
Correct.
purpose?
There would have been a referral to Judge Nunez, who apparently was administrating the part where these evaluations took place.
Did the defense attorney do anything between that day and the day of trial to have a psychologist or anybody or
Not that
any
the record shows.
independent?
Once the Judge Farber denied the request for a referral to evaluation, the matter was dropped. He deferred to the judge's ruling on that.
Okay, you said you had a couple of other
I
points.
just wanted to point out on the juror questioning point, and I'll try to be brief because I know the court does have case law on this, but this particular case is a systematic permitting of the jurors to ask questions. It's not in the judge's discretion to clear up a problem. It's the DA has direct, the defense has cross, the DA redirects, and then the jurors. And then we do it all over again in light of the jury's questions. More direct, more cross, more direct.
But in
Next
this process,
same thing.
I'm sorry, I didn't mean to cut you off, but in the process, as I understand it in the record, trial counsel did not specifically object to particular juror questions. It generally was that you're just dragging this out, it'll be forever.
Well, he did object.
Whereas the argument that you're making are being made for the first time as to specific types of objections to the juror questions.
The defense lawyer below objected to the judge doing it at all.
You mentioned jurors.
Yes, it did. When the judge said, this is what we're going to do, the defense lawyer says, I object. The judge says, I have the discretion to permit this. So there was an engagement there on whether or not the judge has the discretion to do it as a general rule. Then when the questionings began.
Wait, are you disputing that the judge has the discretion to allow juror questions?
What I'm asking the court to refine its prior rulings, not that a judge, although the Court of Appeals hasn't ruled on the issue at all, but that in this case, not just whether or not a juror might be confused and a judge in his or her discretion would allow a question, but to alter the whole course of the trial so that after each and every witness, the judge is going to turn to the jurors and say, now it's your turn to ask your questions, not because they're particularly confused.
But that's the protocol.
Well, that's the protocol the judge used. It hasn't been
No, that's the protocol that's been used in the state of New York.
It has, but it has not been approved by the courts. And I would submit the DA, by the Court of Appeals, excuse me, the DA in this case gives good policy reasons why you might want to let jurors do that it focuses, that Judge Kaye had an investigation, an inquiry, and thought it was a good idea. But that means it's something the legislature might want to do. But they haven't done that. They haven't said, let's have for each and every witness who testifies, we'll let the DA ask questions, we'll let the defense lawyer ask his questions, and then we'll let the jurors ask the questions. Not because they're confused, not because they have some particular issue they want resolved, but just because that's going to be the standard operating proceeding for this trial. And I'm way over my time, but I suggest that that is not appropriate.
Good afternoon, Your Honors. May it please the Court. My name is Grace Villa, and I represent the people. First of all, regarding the judicial diversion point, the people would point out that the trial court properly exercised its discretion in determining that the defendant's essentially eve of trial application to be placed in judicial
Tell me
diversion.
why it's an eve of trial.
I'm sorry, say that again?
Tell me why it's eve of trial.
At that point, the people had...
How long was it before that point and the trial took place?
I believe it was 3 months later that the trial...
So why is that eve of trial if there are 3 months?
Well, first of all, it was 2 years after the case had been arraigned, first
Okay,
arraigned.
so sometimes one doesn't discover that. Why is it eve of trial?
But again, this is sort of context. This arrest happened in 2015. Part of the reasons why the proceedings were delayed, or at least grand jury presentation was delayed, was that the parties were working out a possible disposition of the case. As it turned out, that did not happen. The defendant did not want to plead to an SCI, so the people.
So was it punishment?
No, no, not at all.
So I guess I'm trying to say, if one discovers that someone has a drug issue or may have a drug issue, what is the harm in having them evaluated for the diversion plan when you have 3 months?
I think, Your Honor, as you actually pointed out during Ms. Everett's argument, is that I think what Justice Farrar recognized here is that I think the key issue here was that did the defendant actually have a history of drug abuse?
Counsel said it had resolved 6 months earlier, but defense counsel said it had resolved, any problem seemed to have resolved 6 months earlier, drug issue. But counsel said that the statute says, why don't you speak to what you believe the statute says in terms of whether defendant has, whether the crucial time is commission of the actual offense that has brought them to court?
Well, yes, there are several factors. Does the defendant have a history of drug abuse? Did that drug abuse contribute to the commission of the crime at issue? Whether or not the defendant would benefit from drug treatment in a diversion program. I think Justice Farrar correctly recognized here, first, did the defendant even have a history of drug abuse? I mean, the defense counsel himself, all that he could really say was that he believed that the defendant had some sort of issue with drugs in the past. He could not get more specific about that. And again, I think the actions here is really what really speaks loudly here, is that when this case was arraigned in criminal court, there was no mention at all by counsel about any type of a drug problem that the defendant may have had that would warrant a request or evaluation for drug treatment, or excuse me, evaluation for at least diversion. A year later, in Supreme Court arraignment, after again plea dispositions failed and the people presented to the grand jury and the grand jury indicted, the defendant was indicted, arraigned on the indictment. And again, it's telling that defense counsel at no point at that time requested judicial diversion or mentioned anything that the defendant had any type of drug abuse problem, and again, whether or not drug abuse was a contributing factor to her commission of the crimes in this case. So a year later, when they were before Justice Farber, and defense counsel for the first time asks for a diversion, I think it was very proper for Justice Farrar to take into account a couple of things. That there really wasn't credible proof that the defendant actually had a history of drug abuse, and also that it at all contributed to her commission of the larcenies in this case.
And this is where I'm confused. Credible proof, it wasn't developed, it wasn't brought up. Maybe that's defense counsel's fault. I have no idea. But I'm just saying, what at that point, if there were 3 months in between that point and the trial, what would the problem have been with exploring that?
You know, then the defendant would lie on the defense counsel to bring that forth. Right, the trial didn't begin until 3 months later.
The defense counsel says, can he go before Judge, whoever it is, who's going to evaluate this? What was the point? What was the problem with doing that? How far off course would things have been thrown?
I'm sorry, Your Honor, I'm not sure, maybe I'm misunderstanding.
How far off course would this have been thrown that it would have created some problem in the trial going forward in 3 months?
I guess, well, I mean, actually, the people were almost ready for trial. It's just that 3 witnesses weren't available.
Yes, no, I understand,
but I guess my point is that before that trial actually commenced, there was still 3 months later. If the defense attorney, defendant, really had credible proof that the defendant in this case had or has a drug problem, they could have offered that proof. It was in their court to do that. I mean, it was in their. It was their burden to do that.
So what did defense counsel need to do at that point to satisfy their burden and trigger an evaluation?
Be able to present actual specific evidence that the defendant has a drug problem, and that could have been done by any number of things. Maybe some proof that she had been undergoing drug treatment programs, some sort of counseling, specific examples. The defendant never did that. Defense counsel never did that.
Did defendant herself ever say during any of the proceedings that she had an ongoing drug problem? Was there any?
No, there was never any proof in the record that she did, correct. Even at, to the extent that this is that this court should look into it, and I think you should, even in the pre-sentence report, she told the probation department, when asked whether or not she had any drug abuse issues, drug abuse problems, she answered no. And in the pre-sentencing memorandum, which was very thorough, that was presented by her defense attorney, once again, no mention at all of any issues with drug abuse history or any sort of problems with drugs or having to receive drug treatment. Again,
Do you
I
want
think
to spend a moment on the jury questions?
Oh, if your honors have any questions, I'd be happy to answer any questions related to that.
Okay, thank you.
Okay, great. Thank you so much.
On the question of whether or not there should have been brought out earlier, I just want to emphasize that the statute 215.05 talks about when you do drug diversion, almost always, unless the people consent, you're going to plead guilty, and you're going to have a possibility of a sentence if you don't succeed in the drug treatment. So it may be that the defendant is not going to open discussions on diversion at arraignment, because you can see in this record that this lawyer thought that he wanted discovery, he wanted to see if perhaps there was a defense for trial. Judge Farber actually criticized him when he brought up diversion and said, if you wanted diversion, then you shouldn't have been essentially, he said, jerking us all around, asking for more and more discovery. I submit that's really not the appropriate way to look at this. There's nothing wrong with doing discovery, then deciding that, yes, maybe it's time to look for diversion and plead guilty in the context of that.
How do you respond to your friend's information concerning the sentencing reports where your client affirmatively said, I have no problem, not I am currently in remission or
Right.
I'm...
I acknowledge that's in there, although...
If you could just add to that question, I think the absence of counsel doing anything to try to develop that, if there was really.
Right. All right. With respect to the probation department report, it's true that Ms. Ratliff told them she didn't have a drug problem, but the same report documents that she'd been arrested for drug possession and been ordered by a court in Ohio to do drug treatment. So it's pretty obvious when the judge got the pre-sentence report that she had a history of drug use and another court had mandated drug treatment. Whether or not she...
In the past, right? But there was
6 months
no
earlier.
indication that at the time she pled or at the time this conversation happened that she had a current
Right. Could
drug
I
issue.
ask the court to consider maybe that a person minimizing their drug use to the probation officer, one, is not shocking to hear, and two, that if she has not come to terms with her drug problem in that stage, maybe if we had the evaluation the defense lawyer requested, the person who does these professional evaluations would have said, you know what, just 6 months you were addicted to prescription drugs, and here's the course of treatment we think you should do, and the ball's now back in your court. If you want to have a shot at having these charges dismissed, if you want to have a shot at not going to prison, here's what you need to do. And I would point out, just to remind the court, that when she did get up to Doc's custody, they recognized that this was an unusual situation. They put her in shock. She was out within a year. They had her do programs up in Doc's. So obviously, once somebody with an ability to look at this woman checked it out, they said, you know, this is an unusual situation. This is a person who we're going to treat differently. And then she was released from supervision of parole way before the actual end of her sentence. So I think that this case cries out for somebody to have done this evaluation when it should have been done and not to have rejected it for reasons that the statute doesn't permit. Thank you.
Thank you. Thank you both. Najira Ordonez versus 260 Partners.
Good afternoon, Your Honors. May it please the court. Hal Bierman, Greenberg Charg for Appellants 260 Partners LP and Beach Lane Management. Respondent's opposition brief makes one thing abundantly clear. If this court applies the Court of Appeals' recent precedent in Casey, and before that Regina, and this court's post-Casey decisions, including yesterday's decision in Woodson, the order appealed from must be reversed for 4 reasons. First, the punitive default formula is generally inapplicable in Roberts-related cases because the deregulations were not due to fraud. That's Casey. Second, a tenant seeking to claim a fraudulent scheme to deregulate must demonstrate that it satisfies the well-settled common law fraud standard, i.e., a representation of material fact, falsity, scienter, reliance, and injury, and it has to do so by clear and convincing evidence.
There are a number of apartments here, right? And if you split them into groups, I guess there are a few that were post-Roberts. So what's your argument? Why don't you separate them in terms of the pre-argument and the post-argument? I mean, the pre-Roberts and the post-Roberts.
Sure, Your Honor. There are 37 units at issue. 29 units were deregulated pre-Roberts. 8 were deregulated post-Roberts.
So what's your argument with regard to the deregulation pre-Roberts?
The fraud standard applies equally to apartments deregulated pre- and post-Roberts. No one is arguing that it was improper to deregulate. The question is whether it was fraudulent.
And this was around 2013, I think, because they come into the window when they were registered?
No, Your Honor.
When were
various
those?
Apartments, some were re-registered, some were deregulated.
I'm talking about the pre-Roberts. When were they registered? The latest.
Oh, I'm sorry. All the units were re-registered in June of 2016.
The pre-Roberts.
Pre and post.
Yes.
All the
Okay, but
units
I'm
at
talking
issue.
about the pre-Roberts. Okay. So why under Casey wouldn't that be, why wouldn't we just look within the 4-year period on those cases?
Well, you would, Your Honor. The base date is for all of these cases is November 29,
Okay, but you're claiming fraud with regards to those. that there should be-
No. I'm the
Oh,
landlord.
okay. I'm sorry. Okay.
I'm claiming no fraud.
Let's go post-Roberts. Let's assume the pre-Roberts ones, there's, the Court of Appeals has said what it said. But then Roberts comes out, and then even after Roberts, while your client is getting J51 benefits, it deregulates apartments. Now, how do you, I'm not saying, yes, the court below issued summary judgment. That's a different issue. But why isn't that at least a colorable claim that you go and do your discovery on, because the plaintiffs are saying you knew, because by then Roberts is common knowledge. You knew, and you knew you were getting J51, and you deregulated anyway. So why aren't they entitled at least to discover what you knew to see whether they can prove their fraud?
Your Honor, this case began in 2017. We're 6 years later. They're not seeking discovery. They sought summary judgment.
Right.
And they are not saying that they need additional discovery. If they wanted to take discovery, if they wanted to take depositions, if they wanted to go forward in that regard, they could have. But
why can't they go to trial with what they have and try and prove the fraud on post-Roberts deregulation?
Sure, because in opposition to our cross motion for summary judgment that this court apply the rule, the 4-year rule, not the exception, they were required to lay bare their proof. And in doing so, they presented nothing.
So in other words, there was no affidavit by any of the, say, 8 tenants, because the 8 units were post-Roberts versus the 29 that my colleague is talking about. There was no affidavit that any of them detrimentally relied on some kind of material misrepresentation on this record, correct?
That is absolutely
correct. In other
correct.
words, we just have an attorney's affirmation, rent registration that show what the old registration was, the deregulated rent based on the leases, the new re-registrations relying on the preferential rents, all that stuff. A paper trail, but no one, not a scintilla of evidence by any tenant saying, I detrimentally relied on some kind of material representation to justify a fraud claim.
That is 100% correct.
And
in
that's why you're
fact,
relying on Woodson.
That's exactly right. In fact, that's the fourth reason I was going to get to, that a tenant seeking summary judgment on the default formula is required to submit such a supporting affidavit, and that's both Tribbs and Woodson. And the third reason that I was going to discuss is that a delay in
So can I just, let me clarify. You're not saying that as a general matter that couldn't be a good fraud claim. What you're saying is it's not a good fraud claim here because you moved for summary judgment and in opposition. And what did you put in to show? How did you make out your prima facie that you didn't commit fraud?
There is no burden to prove I didn't commit, that the landlord did not commit fraud. The burden is simply upon, let's go back.
But you're moving for summary judgment.
Cross moved for summary judgment.
You dismiss.
So you're still moving for summary judgment.
Right?
Well, no, I'm sorry, cross moved for summary judgment to dismiss, correct.
On what basis?
Well, on the basis that the 4-year rule applies. And if this court applies.
Did you put in an affidavit that said, I didn't know about Roberts? I didn't did any of your people say, we didn't know that we were supposed to deregulate after Roberts?
Your Honor, there is an affidavit in the record. I believe it's record page 1416. It doesn't go into that sort of detail.
What does it go into?
It goes into the re-registration and why the re-registrations were done, how they were done.
Well, they were done
in good
because
faith.
they were done because the DHCR sent out a notice.
The registration.
If they didn't send out that notice, you wouldn't have done it.
Your Honor, that's unclear. But the idea is that it was complete chaos amongst the real estate industry when Roberts came out. No one knew what to do, including the city agency, and it took the city agency 7 years to come out with guidance from 2009 to 2016, from Roberts to the
So
DHCR.
Roberts came out and clearly said DHCR was wrong. That wasn't unclear. They said DHCR was wrong. So
correct.
Okay, no confusion there. Then Gersten comes out and says DHCR is retroactive.
That was in March of 2012, correct?
Okay.
Where the appeal was withdrawn from Gersten.
Yes, exactly. So that was 2011, I believe. No confusion there. So we have 2011 till 2017, and what now did your clients or the attorney affidavit, what did it say that would suggest that you were entitled to summary judgment given all of those years? Why isn't it enough? Why is it enough to just say that, I mean, I don't even know what. I mean, that you
No,
know?
because simply all of the apartments were deregulated before March of 2012, almost all but one. So there was still confusion, and that's what the affidavit states.
I'm saying, where was the
unrebutted
confusion?
affidavit.
Confusion about what? Roberts says you can't deregulate when you get a J51. So sure, if all those and Gersten says so let's just take that one apartment. When you deregulated it, it was after the Court of Appeals said you can't deregulate if you have a J51, correct?
Correct.
And Gersten said it's
Retroactive.
Retroactive. So how is it that you get summary judgment dismissing fraud? Because at least at a minimum, those two facts should raise, on that one apartment, should raise at least the specter of a fraudulent scheme for that apartment to deregulate.
Because 6 years after this litigation, the tenants have charted their course. They have not put a scintilla of evidence.
Well, what have you put in to justify summary judgment?
There's no need for the landlord, because there's a rule. There's a 4-year rule, and there's an exception to that rule. That exception is if there's a fraudulent scheme to deregulate it as supported by the common elements of fraud. The landlord doesn't have to submit that the rule should be followed. The tenants needed to demonstrate that there was a fraudulent scheme to deregulate.
So your motion was to say you haven't demonstrated it,
Correct.
essentially.
It's a cross,
Okay.
the cross motion.
Got it.
Correct.
Got it.
Thank you, Your Honors.
Thank you, Roger Sacker, Newman Ferrara. May it please the court. I want to hit right ahead with this common law fraud standard. Where does that come from? footnote 7 in Regina. Footnote 7 in Regina cites Thornton, Grimm, and Connaughton with approval.
No. We are all, and it's cited in Casey. And Casey, everyone says.
No, that's au contraire. Casey does not say the common law elements of fraud. We actually went up and put in an amicus brief. My adversary put in, not Mr. Bierman, put in an amicus brief saying, clarify that this is the common law elements of fraud. So you know what we ought to do? Let's let them do it. Let's figure out if in Casey they were, if in Regina they were overturning Thornton, you could have never had fraud in Thornton because there could never be reliance because they were co-conspirators. If in Grimm, where the landlord affirmatively represented to the tenant, they were doing it. They're saying we're being illegal.
But these are not those cases. These are J51 cases that the Court of Appeals, not the legislature, not anybody else, said at a certain period of time, you may not do this. So that's the first time anybody knew it. It wasn't in the legislation. It wasn't anything else. So prior to that, and the Court of Appeals has said not once but twice, if you deregulated prior to Roberts, these are not fraud cases. That's what they said in Casey. That's what they said in Regina. So let's assume that that's what we think they said. I want you to focus on the post-Robert case, right?
Yes,
So what have you put in to show fraud post-Roberts?
I put in a deposition of their principal, and I put in the DHCR rent rolls, and I put in a whole lot of leases. Now,
Did you put in evidence that your clients relied?
no, because we did this under Connaughton.
Right. Okay.
Right. We did this under Connaughton.
What to do is to go back and to do it the way that the Court of Appeals says you should do it.
Well, and this is part of the issue of what Casey and Regina and those cases do. When did the landlord in Regina and Casey register? 2011. 2011, they told the tenants they were rent stabilized. That's what's so different, and that's what there has been no Court of Appeals case that has ever said that you can ignore Gersten. None has said that. That's why this should go up. We have to hammer this issue out.
Why is it not sufficient that the court in Casey says these J51 deregulation cases are not fraud cases? Why is that not sufficient?
Because what they're talking about is they didn't address the seminal issue. They're addressing landlords who deregulated pre-Roberts. That's all they're focusing on. But we have this second plus factor, pre-Roberts, post-Gersten. And if you're saying tenants can ignore Gersten.
No. What I'm asking you is, assuming that you could prove fraud post-Gersten by showing that an apartment was deregulated, that wouldn't be it. You'd have to show that the landlord knew, that the tenant relied. You'd have to show all the fraud. That's why I asked you, did you put in anything from the tenant?
No, and that raises the question. That's the problem with boroughs, right? You have 400 tenants. 400 tenants. You have to show reliance on all 400 of those tenants. First, the initial ones, the first tenants. And if you don't, if I can't go hunt that guy up and show that he relied and put in an affidavit, I'm done. This is why legal aid is calling boroughs a judicial straitjacket.
So what are you saying
it's
that
not
you
a
put
judicial
in?
straitjacket. Boroughs is pretty straightforward. It's a very different case from this because it's 421A, and there was no deregulation. They were fighting over preferential versus legal actual rent. It's a question of whether these tenants getting these registrations had the ability to be able to file overcharge claims earlier than they did. That said, what I need clear in my head here is if the fraud claim was dismissed, arguendo, that does not knock your claims of the 37 tenants against the landlord for overcharge, correct?
The 4-year rule would apply.
4-year rules. In other words, you're fighting here over the default formula.
Correct.
But otherwise, if the landlord overcharged by deregulating and charging a market rent when your rent should have been, as in one case, bizarrely, $100 and some odd, which was the last legal regulated rent collected for one of the apartments. Am I correct? I thought I saw some of that in the record.
There's something,
Whatever, but you get the point. So then obviously there would be an adjustment. There would be a base rent that would have to be set. Add the guidelines, and there would be overcharge and treble damages, correct?
And this wraps us into the same problem. If you're a tenant who moves in 2017, you got to go find the guy in 2013, convince him to put in an affidavit saying, because remember what the fraud must do. It must taint the rent on the.
I mean, but that's what it is. That's what Grimm said it is. It's not just you deregulate, it's you have a fraudulent scheme to deregulate.
Yes,
what
but
did you
where
put
was the
in-
fraudulent scheme in Grimm?
What did you put in that you believe, and what were you following? What case law were you following when you put in your papers? What evidence do you have that shows you have a right to?
Coninson, this is the Court of Appeals words, not a generalized claim of fraud, fraud within the context of Grimm that is a scheme by the landlord to treat an apartment, and I'm paraphrasing the end.
Grimm involved apartment improvements or bogus improvements, am I correct? Here, we're not dealing with bogus improvements. We're dealing with the fact that landlords before Roberts believed they had a good faith basis to deregulate, even if they took J51 benefits. And it was industry-wide.
But this is the
Bear
difference.
with me.
Bay State. Bay State.
So if the landlord that may not be aware of Roberts or may not be aware of Gerson, I'm not making excuses, but they were just simply following what had been in effect for almost a decade before Roberts was decided in 2009, correct? I'm deregulating because I believe I hit the $2,000 number or I hit the $2,500 number. We're not dealing with, I'm charging a market rent based on bogus apartment improvements that never took place.
But it's bogus increases you weren't entitled to. That's the problem. They've tainted the entire rent history by doing this. And this is why, let's let the Court of Appeals say whether or not post-Gersten failures to register constitute a fraudulent scheme and the default formula applies.
At this point, you're saying that you should be entitled to send this back on certain of the apartments to consider whether there is fraud because the landlords failed to register anything post-Roberts and charged a preferential rent, which
They charged a market rent.
Charged market rent preferential in some cases, which would otherwise not be done.
Is that,
That's
you're
what
saying
you
you
have?
get summary judgment on that?
I get summary judgment on Coninson because the landlord engaged in a Grimm-like scheme. It doesn't matter if it's bogus improvements. They had an affidavit from the tenant saying, I know it, the Bay State tenant saying, I know the improvements were bogus. The landlord told me I wasn't doing them. And in that case, you're saying that the post-Grimm tenant, Grimm, the tenant who moved in after these tenants, that they're not entitled to the default formula. That's what you're saying, Your Honor. Is that right?
No, I didn't say
That's
that.
what Burroughs
Grimm,
says.
And first of all, Grimm, there was no,
We don't have to answer the question.
Right, no, I
so you
understand.
know.
I was posing it more as.
But I understand you're animated and very, very involved in this very important discussion.
Thank you.
Yes.
Thank you, Your Honors. In Grimm, the landlord deregulated a unit with a legal rent of $587 without any justification and even demanded that the incoming tenants perform their own renovations in exchange for lower rent. Even then, however, the court held that the lower court should have investigated whether the landlord engaged in fraud. It did not find that the tenant was entitled to the default formula. And I quote, "Our holding should not be construed as concluding that fraud exists or that the default formula applies."
So let me just, are you of the opinion that post-Roberts Gersten, that should go back for a trial on the issue of whether, because this is all evolving. This is not something that anybody knew a year ago this is the way it was going to go. So why shouldn't the tenants be able to go in, or at least the one tenant that's post-Roberts Gersten, why shouldn't that tenant be able to prove this landlord knew it wasn't supposed to deregulate because it knew about Roberts, it knew about Gersten. It was taking J51s. It did so anyway. I relied on its false representation that it was allowed to do that, and I lost money because of it. Why is that not a good, at least tribal issue?
Because there is absolutely no proof. Nothing was laid bare in opposition to summary judgment.
I think because no one knew how the law was going to shake out.
Well,
we're just a few months after Casey. No one knew how this was going to shake out. So why should we hold someone to a standard when no one knew how it was going to shake out at the time?
Because there was a chance to develop a record for 7 years. The note of issue was due to be filed in June of 21. If they wanted to take a deposition in this case, a single deposition wasn't done. The deposition that's being relied on is relied on in another case. And when you look at the text of that transcript, it makes clear that the manager was confused. Quote, we were all trying to figure
But
out.
that's a fact issue, and why can't they put their own tenant on? If you say by the same issue, you could have deposed their tenant. Put them on a trial and see what happens.
There was no need for me to. I didn't have a burden. There's a rule. We're only saying the 4-year rule applies. We're not saying these tenants are not rent stabilized. We're not saying they're not entitled to those rents. We're not saying they're not entitled to overcharges. We're simply saying that the tenants are not entitled to the punitive default formula. Thank you, Your Honors.
Thank you. Gillespie versus Kling.
Glad I don't do real estate law anymore.
You have 2
Good
minutes.
afternoon, Your Honors. Thank you for the time. My name is Richard Altman. I'm here for Mr. Gillespie. I only want to make a couple of points. The anti-SLAPP statute has been detrimental to good faith defamation cases like this. It covers a communication in connection with an issue of public interest. I can't dispute that a social media site is a public forum, but is there anything more private than the details of a marriage? How can you possibly convert that into a public matter? If a couple wants to be famous, if a couple wants to circulate its issues in a public forum for the world to see, fine. But if you're going to permit, if this court is going to permit an ex-spouse in violation of an agreement to not post anything on social media, to say whatever she wants about her ex-spouse and be immune from a defamation claim, then there is no private.
Well, wait a second. Let me just ask you. She did the podcast before they signed the separation agreement, right?
That's correct.
So there was no agreement of her at that period of time for her to say anything.
But she did it after. And the case also contains claims based on podcasts after she signed the agreement in the separation agreement. And there's also the fact that a settlement of all claims was carved out of the separation agreement. All I would suggest is if we reverse the genders here and an ex-husband.
What is post-separation? What did you allege post-separation agreement that was published?
She continued to publish articles following.
First of all, you can't. That's not enough to plead a defamation claim. What specifically did you? Because as far as I can see, the only thing you specifically, that word was having a hard time for me to get out, was the podcast. Did you cite a publication?
The podcast continued after the separation and after the divorce.
Okay.
So I only would suggest that if you looked at it from a gender reversal point of view, if an ex-husband goes on social media and says, well, you know, my ex-wife was a prostitute, my ex-wife was abusing my children, would the wife not be able to bring a defamation suit?
Thank you.
I mean, Me Too.
Thank you.
Has its limits.
People versus Joel Levine, I believe it was, Levine.
Good afternoon. I'm Glenn Garber for Joe Levine. Dr. Levine was convicted on two misdemeanor counts of sexual abuse in the third degree. He got a conditional discharge, but he was a doctor who there's a lot at stake for him. He lost
We
his
know what
career.
the facts are, so you can.
What?
We know the facts. I
Yeah,
think there's a
okay, so let me just there's 2 points.
There's a question here.
All right.
So your whole appeal rests on arguably 2 statements in the summation, correct?
Correct. Okay, so there are 2 points in summation that I think require reversal in this case. The first one is that the prosecutor essentially invites the jury to misapply the law on sexual abuse in the third degree and shifts the burden to the defense. And this is the language. It appears at the appendix on page 469 and 470.
So we know what the language is, and it is inartful. But in a case like this, wasn't the prosecutor really saying that the woman does not have to say yes or no to give consent, especially under the circumstances where, in this case, she says that she was frozen and she couldn't say anything. She was so shocked. So look to other indicators, other things, to determine whether or not she acquiesced or not. Isn't that what she was trying to say? Isn't that what the
I don't think that
judge
is
was saying?
a fair reading at all of those comments. I mean, and I'm not going to read the comments in total because you have them, but she's talking about the statute. She's talking about sexual abuse in the third degree, and her comment, and just focusing in, and I ask you, when you go back in the jury deliberation room, I'm going to ask that you view that, and she just talked about sexual abuse in the third degree, from a different lens. And she talks about the fact that the victim or the complainant shouldn't have to say no or stop. And then the question is, why?
So what does she mean by that? Shouldn't have to say no or stop. What is?
But in the lead up, she says that. Why isn't it the responsibility of the actor to stop? That's the language in the context. She's saying, she's true. The complainant doesn't have to say stop because her behavior could mean stop. That is a true comment. But the next comment right after that is then shifting right to the defense saying, why isn't it the responsibility of the actor to stop? And she's inviting them to look through it from that lens. Not only, I mean, I've been doing criminal defense work for a long time. That's like a red flag, shifting the burden. But also in a case like this, when you're talking about the term, the language is, well, it's sexual contact without consent. Consent in this context is the person doesn't expressly or impliedly consent in the actor's conduct. That means that if she's accepting something reluctantly without protest,
Can I
that is
ask
not
you,
criminal.
what was Dr. Levine's defense?
Dr. Levine's defense?
Yeah.
So he testified and he gave a different account than the complaining witness in the case. And he said that they went to the movie theater.
That it was consensual.
That
It was
yeah,
consensual,
yes.
right? And why did he think it was consensual?
Well, what he testified to was that she had she put her head on his shoulder. She had spread her legs. She put his hand on her thigh, and then he also put his hand on her breast. And that was what he testified to. And she testified to a different set of facts.
And right, so his lawyer was saying that his lawyer say she never said no to him? She never said don't do that? Isn't that what her lawyer argued?
That was me, by the way. But
I'm
yeah,
sorry,
I did
yes.
argue.
Didn't you
Yes, I
argue
did
that?
argue that. I
Right?
did. But we're
So in response to saying she never said no, she never said stop, you're saying it wasn't fair for the prosecutor to say you don't have to say no, you don't have to say stop? Those things aren't required?
No, what I'm saying is that even if you want to accept her account, okay, where she says that she sat there silently, that she started to cry, she thought she might have said no, but there was an inconsistency on that. And under all the circumstances, that could be a lack of that could be consent. It could be that she's acquiescing, she's tacitly going forward with it, and that's an argument that I made on the summation. That's an argument I'm free to make, and the comments by the prosecution take that away from me. It's not just about he said, she said. I mean, I do think that my client's testimony carried some weight. They did acquit on one of the counts. But even if you're looking at it just from what she says, and that's the way the jury wants to view it, what the prosecutor says shifts the burden to him, takes out that they have to prove beyond a reasonable doubt that he had the intent to engage in sexual conduct without her consent.
What's the language of the statute specifically?
Well, the language, sexual contact is sexual contact without consent. And consent in this context for the B misdemeanor is that the person doesn't expressly or impliedly acquiesce in the actor's conduct.
And so what the prosecutor is saying is saying yes or saying no is only one way to find that there was consent or not consent. I'm asking you to look to the facts. What happened?
But
isn't that really what she's saying?
She's making a policy statement because she's saying, why should it be this way? Why shouldn't it be the actor's responsibility to stop? That is what she's saying. And that is not what the law says, and that is not what consent says in this situation. And it shifts the burden to him, and it takes away from me as a trial lawyer impliedly acquiesce, that she tacitly goes forward with that. The prosecutor's comments take that defense away from me. Regardless of, I'm going to obviously get up there and argue my client is credible and you should believe him, but I'm also arguing that even if you want to accept the facts as the prosecution presents it, they have not made the grade here. They have not met the burden, and the impliedly acquiesce is very favorable language to me that shouldn't be taken away and watered down in the way that it was. That's my point.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Juliana Susu for the People. The two contested comments in the People's summation were proper and do not require a reversal. I will start with
one of the most important things is that it's like a bedrock principle, is that you don't shift the burden in a case where the trial and the defense before the jury is everything. So here we have this really confusing language where the prosecutor is saying some things that really do sound like burden shifting, the responsibility. When you go into the jury deliberation room, going to ask you to view it from a different lens. I don't know what the other lens was, but a different lens. And it's the responsibility of the person who's experiencing unwelcome, uninvited, non-consensual touching. Why is it her responsibility? Which is really saying, why is it her responsibility? Why isn't it his responsibility? Which, the judge didn't even explain it. He seemed to have trouble explaining it on the record because it just is not clear in the way he tried to explain what the prosecutor was doing. So why is this here not something that should be reversed because it shifts the burden?
Well, her just saying that it's the responsibility was not talking about the defendant's responsibility at trial in what evidence he had to prove to the jury that the victim consented to the conduct. The portion when she says responsibility has to do with the fact that there is a responsibility on a person subjecting someone else to sexual contact to look for those verbal or nonverbal cues or indicators that it is being consented for before going forward.
Well, why is she using words like responsibility? Look at this from a different view. Responsibility sounds very much like burden of proof. It's a responsibility. Why isn't it just, she says that she couldn't say anything because she was so shocked. So she didn't use words like yes or no. So look to the other factors that she testified before you, that she used to let him know that she didn't want him to be doing what she was doing. Why are we talking about, a different look through this, through a different lens, and it's not her responsibility, it's his responsibility.
I think her talking about the different lens was she was going off of the comments that defense counsel made in the summation, talking about how the victim did not say no, she did not tell the defendant to stop, but that there is no legal requirement in the statute that she had to do those things in order to show lack of consent.
Well, then when she starts to go into the legal requirement, she's talking about the burden, isn't she? I mean, she's talking about the law, which no one's supposed to be talking about except the judge. But isn't that where she's going with this? Which is why it's so dangerously crossing the line?
No, again, I don't think she's talking about the burden of proof. What she's talking about is what is the responsibility of someone that's subjecting someone else to sexual contact, and that is to look for express or implied consent before going forward. That's what she means by responsibility. And even if there was some type of misunderstanding by the jury that the burden had shifted, certainly the court's thorough and lengthy instructions on the burden of proof, staying with the people throughout the entire trial, particularly before the deliberations, would have cured any misconception as to that.
Well, I think burden of proof is the kind of thing that's so important that I don't know that we want to wait for just the judge's instruction where the prosecutor is able to discuss it and then the judge overrules it. The judge didn't give any limiting instruction. The judge let the prosecutor say it, then reinforced it by not saying anything about it, which doesn't change when you get the charge. They wouldn't know that they weren't allowed to do this.
I would just like to point out that, but the heart of the argument is that the prosecutor misstated the law and then therefore put it on the jury to ignore the law. But she didn't misstate the law when she said that it is the responsibility of the actor to stop unwanted sexual contact. So it's unclear how that would have shifted the burden of proof to the defendant to then prove that to prove anything, to prove that the victim did consent.
Let's talk about the next statement, because it seems to me that the prosecutor injected herself when she says, you know, as a prosecutor, what the prosecution believes. So let's talk about that, the acknowledgement of responsibility as it related to the defendant.
Sure. In making that statement, the prosecutor was not injecting her personal opinion or the district attorney's office's personal opinion as to the defendant's innocence or guilt or his credibility in the case. When looking at the comment in its full context, the prosecutor was arguing to the jury how they should interpret defendant's testimony that he regretted what happened. Now, of course, yes, it is admirable that he's acknowledging responsibility. That does not mean that based on that sole testimony, you should find defendant not guilty, especially when taking into consideration the evidence, particularly the voicemails, prove that defendant did not actually feel regret for what happened. And when you have a case resting predominantly on the credibility of the witnesses, like we did in this case, and defense counsel just spent a portion of his summation attacking the people's main witness, the prosecutor is allowed to present that evidence and argue why the jury should not find the defendant credible. I see my time is up. If there's no further questions, ask at your phone. Thank you.
Thank you. So just briefly, on the second point, I mean, with the prosecutors, it goes on for about a page, maybe a page and a half. But the comments are, I think, very clear, and I'm not going to repeat them. They're on pages 461 of the appendix, but I'll just focus on what I think this boils down to, and I'll quote a little. As a prosecutor, when the prosecution believes that someone committed a crime, and then she says being remorseful, being regretful, objection, there's a little bit of a break there because I object, it's something that's admirable. And then she goes on to go to voicemails and say, he's not the slightest bit remorseful. And I think if you read that together, she's basically saying it's not admirable from the prosecutor's perspective. Trust me, not him, he's not remorseful. And I do think that is a fair reading of what that exchange or what that comment is, even with the exchange of objections.
Counsel, wouldn't it be an argument that she was asking the jury to weigh the credibility of his so-called remorse in the courtroom versus how he called her close in time to the event to have a coffee, or did I make you uncomfortable? And just weigh, did he sound like he was remorseful when he made those phone calls versus how he sounds in court? Is that fair comment? Isn't that fair comment?
That would have been fair if she's saying, look, this is a unbelievable story. His remorse is not a fair remorse. And let's look at these voicemails to show that what he's testifying to here is just BS, for example. But she doesn't do that. She says, as a prosecutor, remorse is important to us. And she says it twice. I mean, she said, as a prosecutor, when we believe someone committed a crime, it's admirable for them to be remorseful. And then she goes in and she attacks the remorse. If she did it the way you're suggesting, that's fine. That's not what she does. She wraps it around the imprimatur of the government and induces, that's the language from the Supreme Court, induces the jury to trust her judgment over their own. And I think that's what that comment does. On the first point, just very briefly, I do believe I requested a curative charge and asked the court to correct that, and the court did not. And it certainly, I think, rang as a burden of shifting problem, you know, primarily, but it also, I think, was a misstatement of the law, and asked the jury to look at that, impliedly acquiesce in a certain light that limited what that language actually does for the defense in relation to the burden of proof. Thank you.
Thank you, both. Yusuf versus Horace Plaza.
May it please the court, my name is Cheryl Eisberg-Moyne. I represent the appellant. I would like to bring to this court's attention a very critical part of the record, which is the video at 1 minute and 9 seconds. It shows the first tile that was being removed. He was injured on the removal of the second tile. We see the magnitude here of the problem because when the tile was removed, it collapsed in half. And you can go back and forth on the video and you will see that it just collapses in half. This was a waterlogged, drenched barrier tile, and there were 10 tiles that needed to be removed. This was not normal wear and tear. This was an emergency repair done at the behest of the owner and managing agent. So this is a situation where the case falls precisely within the ambit of Labor Law 240 and 241-6 and 200. We have a very strong case here also on the common law negligence claim. What's missing here, the record is barren of any denial by the defendant, the owner. There is no affirmation, no affidavit from the managing agent denying that they told plaintiff, look, it's an emergency situation, we can't get down to the site, start removing the tiles, initiate the repair, replace the barrier tiles. This was a ceiling that needed to be stabilized. There were patrons in the dining room of the Dunkin' Donuts, and they were imperiled because this could have collapsed at any time. There is an affidavit by Mr. Yosef that this had happened twice before in the months previous. And the record is full of all of the documentary proof that the boss of Mr. Yosef had emailed the owner and the managing agent. There's over 30 pages of emails in this record. So based upon this, it was erroneous to grant summary judgment to the defendant when summary judgment under the statute here should have been granted to the plaintiff.
Thank you.
Thank you.